īpaši vakardienas izcilās balvas, par ko arī liels paldies Eiropas Savienības tiesai. Tie, kas nezina, ko tas nozīmē, tad vēlāk noskaidros paši, bet ladies and gentlemen, I'm very much glad to start today's conference. And as I've already noted in Latvian, I appreciate that after this quite long week of tiresome intellectual discussions and not less tiresome physical activity last evening in the stall, which was, I understand, not just understand, but which was granted to us by the European Union, by the Court of Justice of the European Union, to members of certain distinguished. Yes, indeed, they are precise, and we as lawyers we have to respect precise. It to not only to commemorate the anniversary of Latvia joining the European Union, but also to show how active Europe is and how versatile Europe is, because those of us who were present indeed enjoyed not only music of the Latvian origin, but also music from the other member states. Of course, Friday after this rather intensive week is not always an easy moment when we could concentrate on abstract things. As you can see from our schedule of today's conference, comparing with other topics that we have discussed, and the one which is particularly dear to me and to my mind, legal ethics, today's conference concentrating on legal theory and the national dimension in legal theory brings us to way more abstract level than we have been in all of our previous discussions. And for this reason, I'm certainly very happy that these topics, as you could see the heading, how national is the theory of law in the common European legal space, we would not be able to entirely discuss and uncover the nuances of this topic without assistance of, let me say so, major thinkers of contemporary time, of the region where Latvia belongs to. And this is also quite important to, first of all, after this week of discussions of Latvian legal issues, have a wider spectrum, not only in relation to the European Union, which we have in every topic already referred to, but also in relation to the region in which Latvia historically, traditionally, and of course nowadays politically belongs. As you could see, we have to be starting today's session with a speech of our distinguished rector, Gunārs Bērziņš, but unfortunately some sort of mismatch of planning had made Mr. Bērziņš to tell me, to tell you on behalf of him, that he will address us. He will address us online. Apparently that will happen for our summary session, headed by member of European Parliament, Gunārs Vīģārs, and Justice of the Court of Justice of the Ineta Ziemele. So, rector's speech will be moved on time-wise for the summary, but we will start today with prominent members of academia, and let me also introduce you to those who are here. Most of the panelists are already well known. You have read, you have met them, so maybe some of them do not even need an introduction. I'm particularly happy to introduce Elina Grigova, who is my colleague in the University of Latvia Department of Legal Theory and Legal History. I have to say that in addition to her academic achievements, the colleagues in the department have noticed already for several years that best student theses are coming from students who are tutored by you. So we see that you are indeed prominent in selecting not only topics to be researched, but also those younger generation lawyers, of whom many do participate also here today, basically bring up the younger generation. So you will be the one who will start with your introduction to our today's discussion topic. It will be followed by a presentation of a prominent Czech scholar and also legal practitioner, if I may say so. Professor Zdeněk Kuhn, who is not only professor in Charles University in Prague, but also judge at the Constitutional Court of Czech Republic. So this, at least from my perspective, gives this unique and valuable opportunity to add to legal theory the practical dimension, but more importantly, to be able to implement the legal theory, the theoretical considerations into the practice of interpretation of law and application of law. And as a third speaker in this first part of the morning session, devoted to theory of law and national dimension and theory of law, will be our founding member of the Public Law Institute, who is behind this leading session for many, many years, to be more precise, for 20 years now, Helios Levits, who you know not only as a former judge of the Court of Justice of the European Union and the European Court of Human Rights, but also as the president of Latvia. So this was one of the times when most of Latvian lawyers have been happiest at its highest stage, because a lawyer in the head of the state is always bringing this Marcus Aurelius element to the governance. And in several aspects we can see that this has been great for Latvia, while Helios Levits was the president of our country. We will be heading today's session together with my good colleague Anna Svelta, who is Deputy Secretary of State. So this is the top-ranking position of administration in the Ministry of Justice of Latvia. And the responsibility of Anna is legal policy issues. So we have this benefit of someone who really determines legal policy as a political agenda, or as part of the agenda, participating and also managing the discussion. And my name is Laura Sliep. I'm also the Public Law Institute members and practicing attorney, and also a lecturer in the University of Latvia Department of Law. I think we start this session.
You can start, yes, because today my duty is to help you.
Well, I was saying the other way around. I thought that the hardest part of my task today has been already completed.
Yes, and we can start, as Laura said already, that skipping from very practical issues to very theoretical level can be hard. And that's why we have like three very prominent introductory speeches before we will hear 4 referates later on today. So I think I will give floor now to the first introductory speaker of today. Elina, please, the floor is yours.
Yes, thank you very much. And thank you for such a kind introduction. Well, I believe it would be nice if my students who wrote the thesis under my supervision would be here, because one of them wrote about legal formalism, which would be an interesting topic as well under this question. So I've put together a bit the ideas and more even the questions I wanted to ask, because first of all I can say that I won't give a ready answer to this question. I just wanted to see what does it really mean. Namely, the thing with which I will start is the notion, the theory of law, and what does it do? Well, a feature that has always fascinated me in the discussions and presentations of academic philosophers is the need, firstly, to clarify notions, the notions used, namely to understand whether we give the names the same meaning. And through various public debates, I have often come to the conclusion that many disagreements arise from the fact that people using the same words give them different meanings. And the inevitability of this fact is perfectly evidenced by the semiotic triangle, which I wanted to remind myself at the beginning. And so, yes.
Don't worry, it moves. This is an internet, so we see.
Yes. Well, the thing which I use to clarify where the problem lies is this semiotic triangle. Because you need to understand that there are at least three parts of every symbol, which is a word. And if there arises any disagreements, you need to stop and to think. Are you using the right words for it? And do you understand, do you put the same definition, the same concept in those words? And what are you actually talking about? What is the referent? What is the object you are talking about? And so I took this semiotic triangle from a study book written by German professors, Ruther, Fischer and Wirth, and I think it might be pretty useful. And the same goes from, I believe, the same goes for the theory of law. When we say that the words are the same, but what questions, what topics does it include? So what is the concept of legal theory? And so I would propose that it isn't strict of legal methodology or philosophy of law. Namely, it includes also the questions which are philosophical in nature and which concern legal methodology. And so when we ask this question, is there a national theory of law? We should address this question as well. Is there national legal philosophy? Can there be national legal philosophy? And what about legal methods? Can there be national legal methods? Or are they universal and we just use them differently? And I also wanted to include these three functions of legal theory because that's the way you can answer this question which is given as the main topic today. And so the function, the first function of legal theory of such is empirical, and that is based on observation. We observe the real life, we observe the praxis in the executive branch, the praxis exercised by the courts, and so that is a way just to look at what is happening and what do the courts do, what do executive branch do, and so on. The second function and the second way of answering this question is analytical. It covers topics from legal language till the structure of legal norms, structure of legal system, and that's also a way to look at this question. And the third function is, I believe, the widest one, the most diverse and interesting normative function, and it concerns the understanding of law as such, the notion of law, grounds of the validity of legal norms, methods of application of law, and so on. And it is important to emphasize that the theory of law, along with the philosophy of law, is not limited to the description of existing law, but it also addresses the issue of justice, fairness, and correctness of law as such. And so my proposal would be that when we talk about theory of law, we also understand that there is philosophy of law and legal methodology as well. So from this point of view, we need to look at the smaller questions which arises from this big one. And the smaller question, which isn't so small at all, the notion of law. What is law? The practical perspective of this question is the understanding of legal relationship. Because when we, the search of essence of law and the creation of definition and formulation of law, of course, is not the primary task of courts. The courts do not have to define what the essence of law is. But it is the task of legal science. But it has practical consequences because legislation and adjudication need to reflect one or another of these concepts, what is law. And here I have chosen one recent thesis which was written by Professor Zeman in a recent publication in University of Arts in May. And I took out these two sentences. I don't know, I hope I translated correctly, but I found it very interesting the idea that law is a system of legal relationship, and the system of legal relationship of people is endless. I hope the translation is more or less, well, we can discuss the notions as always. And I found it interesting that these two aspects of this thesis, of this statement, is there an endless legal regulation? Should there be? Is there? And it also leads to the next question, actual relationship and legal relationship. What is the difference? Should there be a distinction or shouldn't there be a distinction? And that is the question which is addressed in the philosophy of Kant, namely the sphere of is and the sphere of ought. Do we have to distinguish them when we talk about law and when we apply law or not? And the thing not only me, but I believe everyone has noticed is that in the practice we can't distinguish them so strictly as it is possible in philosophy. And I chose just this one fragment from the judgment of Constitutional Court, which I believe perfectly illustrates the concept of how we merge together these two spheres. This is and ought, and the interesting question here is about who can decide whether something from is should go to the sphere of ought. And this fragment from the judgment, I will read it so I can stress the notions I believe are important in this particular example. So the case was about family law, and family as a social institution is a social institution and based on understanding and respect and founded on close personal ties that may be identified as the social reality. Even in the absence of biological link or a legally recognized child-parent relationship, de facto family relationships can exist between a child and the person who has taken care of the child, depending on whether they live together, on the duration and quality of the relationship, as well as the adult's role in the relationship with the child. The existence of close personal ties follows from a concluded marriage or the fact of kinship. However, in social reality, close personal ties also developed in other ways, for instance, as a result of de facto cohabitation. And the first sentence of Article 110 of the Constitution defines a positive obligation of the state to protect and support all families, inter alia, de facto families. So that is the question, when the actual relationship could become a law. And I would say that the similar concept is the European consensus, which stands somewhere in between. On the one hand, it is the sphere of is. If you look at the other states which already have introduced a mechanism and you use it as an argument in the court's judgment, then it shifts this understanding. I just only put this Radbruch's thesis beneath it because I think we don't have still a complete answer where the margin lies, where the line lies, because if we take it the pure statement, an ought statement cannot be derived from an is statement. It is what Radbruch wrote. Is it even true? And how can we set the margin? Which reality can we transfer to law and can we protect by law and which not? And I believe the answer to this is partly a national one. It can be a national one. One of yesterday's judgment of Court of Human Rights regarding prostitution was this issue. And the court stated that there isn't consensus yet, and so we have to leave it to the national law, and the national law gives us the answer. So the margin of appreciation is also the one which leaves the space for the national answers, even in the field of legal theory and legal philosophy, even more so. So, yes, the next thing I wanted to address about legal theory is where can we find law? Well, namely it is the doctrine of sources of law, and all the legal scholars speak of the national doctrine of sources of law, then still the understanding is conceptually unified in the European legal space. And I won't go into depth because we know the meaning of law and the importance of law. But what differs from one country to another is the practice of citing and indicating sources of law in court rulings. If there is, of course, a complete consensus on the need to indicate applicable legal provisions in the judgment, there is no doubt about that. We need to say what law and what provision exactly is applied. The greatest diversity is the treatment of quoting and directly indicating subsidiary sources of law, and especially legal doctrine. And in Latvia, it is common for court judgments to include references to scientific publications. And it isn't seen as a way of diminishing the court's authority. It is, I would say that is a national feature, because the courts in Latvia are not afraid to cite legal doctrine and do it very widely. The question which arises from this fact is the possible convergence of judiciary and legal science or academia. Is it a problem or is it not? Because in the small countries, it is very common that professors also sit at the court. And does it help to further develop legal science, legal theory, or does it not? So it's a question, which way would be better? Is there a necessity for strict division of academia or court? Is it even possible? So it's an open question. I don't know, perhaps someone will address it later on. So, and the last things I wanted to mention, some of these national peculiarities of theory of law. If we want to answer this question, we need to step back and to look at the law as itself, and then we see that law isn't only national phenomena and it isn't a universal phenomena only. It is both of them. Law includes national elements and universal elements. And so the same goes for legal theory. We can discuss and debate only which parts of legal theory are the universal ones and which are the national peculiarities. And if we talk about these national peculiarities, then I just can remind that law is an integral part of culture, and so that leads us back to the historical school of jurisprudence, to Carl Savigny, and we can't say that we are purely national law theory, because there are many elements from this historical school of law. And I chose this statement from Savigny about law. He wrote that law is first developed by custom and popular faith, and next by judicial decisions. That points out why the legal theory developed at courts are so important in the European continent. And so next by judicial decisions, everywhere therefore by internal silently operating powers, not by the arbitrary will of the lawgiver. So we know Savigny wasn't so fond of lawgivers because he didn't think of them as suited for making the best laws. And so the criteria for correct and just law is the spirit of people, or Volksgeist, and that is the national park. The modern successor of this Volksgeist notion is constitutional identity, and again, when we want to find national peculiarities, we need to further ask the question, how much this constitutional identity influenced theory of law? And then, when we can say this is a very specific element of national identity which is reflected by legal theory, then we can say, okay, this is the feature of Latvian law or some other law. But if it is overall universal, rational understanding, then it is united for everyone, for every legal system. Thank you very much. That would be from me today. I hope that there are some questions we can later discuss. Thank you.
Good questions. Thank you, Emily. Do we give floor to everyone to discuss, or we start with?
Maybe we can do with questions after all the introductory speeches.
Because I suppose that there certainly are questions. At least I have one, which was, again, remarkable when I was introducing Professor Kuhn and also looking at us here at this table. I thought that this is a rather phenomenal feature that people who are developing legal theory are able also to implement it by core judgments. And not always is that the case, and not everywhere, in all jurisdictions. May I ask you to, Elina, to perhaps provide your hypothesis on how is that beneficial for the practice of law, that scholars are sitting at courts and also being part of the court panel and deciding issues, or on the contrary, that complicates this very important mission of efficient judicial process?
Yes, thank you. Well, I believe it is a very effective way in times of transformation. When you have to transform the legal system, it is easier to do so if the justices are also legal scholars. Because then when a legislator fails in some aspects, there are judges who can make it good. And I believe it is a good thing, and it is even necessary in the times of transformation. Yes.
Right. Which I can just make my small remark that I guess Latvia has lived through times of transformation constantly.
I also have a question for you. You mentioned that the social reality and legal reality, or what is real in social life and what is real in law, sometimes doesn't match. And I think, well, it's said a concept of mother in a biological reality, in social reality, and legal reality, they could be totally three different persons. And in your opinion, does it, so that those realities sometimes does not match, and there are many realities, and each claim to be the real one, do you think it contributes to the development of the society, that we have so many realities? Sometimes they match, and sometimes they don't. You have to solve the problem. Does it contribute to the development of the society, or just the opposite? It sometimes makes life for people more complicated, and if the legal reality is sometimes not the biological reality, then it complements to the not believing that law is actually something real and true.
It's a very complex question. Let's contribute. Well, in Europe we believe that diversity is a value, and so the more diverse the world, the perception of the world, the more we can get from it, the more we can learn. But I don't know, if there is a conflict between different realities, I don't think it's psychological, I don't think, this conflict of mind, but I think you can't avoid it. Absolutely, it is unavoidable. you can't make all realities merge into one. There will be different aspects. Well, that is the question about the reality as such, the truth as such. Is there objective truth, or are there many perspectives, or maybe too many subjective truths which we combine together? But I believe it still contributes, yes, it contributes because it gives you different aspects from which you can look at life and understand things you didn't understood previously. So there must be a thing like that also. Thank you.
I have a question to you. You stress that it's in times of transformation, it's a good thing that legal theorists or legal scientists are also at the same time judges. My question is why, especially in the times of legal transformation, in my view, legal theory and legal practice, court practice, are the two coins of the same medal. Because the judgment should be written in a scientific manner. Because legal theory will criticize the judgment, and criteria, as I say, if the judgment is not satisfying the scientific criteria, it's a bad judgment. And therefore, I think this unification of in one person, judge and a legal scientist is a normal, is a natural, because also when the judge is preparing the judgment, he is applying legal theory. I cannot see the difference. And that means, my question, why in the times of transformation? Times of transformation deserves a specific attention, but in a normal times. What do you mean?
Especially in the times of transformation. I must add one thing. It is also not a good thing, only a good thing. It is a risk as well. Because, well, National Socialism in Germany in the 30s, we see that the transformation of legal system was exercised throughout court practice as well. And so times of transformation allows this model to exercise this transformation more quickly. If you can do it without legislation, the judges, the justices can transform the actual life because they have direct influence in difference from legislation. But in normal times, it's also a good thing because justices can correct mistakes made by a legislator. I wholly agree with you on the thesis that in legal science and in law you can't distinguish between practice and legal theory. It is impossible. If it is, I don't know, perhaps in other sciences we can talk about that, but not in legal science. You have to apply legal theory. But the risk, again, might lay there that legal science, as every science, includes some creative factor. And the question is how creative and how freely can a scientist work, and how free is a judge. The judge must apply the law. A scientist seeks for truth, which is something bigger.
But the judge is not executing or applying his own theory. He is applying legal theory as a whole. Yeah.
As a whole, but he can further develop it. As we see it in several judgments. The judges, the justices are the ones who further develop legal theory.
Yes, if there are any other questions, Ilse, yes, please.
Good morning. I have a follow-up question to Anna's question, triggered by your different realities and as a law to describe reality. For me, the real question is the role of the law to describe reality or to establish the principles? And for me, the second is the key, because otherwise we are following this usual trap, that we try to describe each and every situation, and then we are limiting this creativity of judge to interpret and develop legal theory.
Well, yes, I can add to that we don't have to describe reality in every smallest detail. in principle, have to correspond to it. It can't be in contrast to the principles existing in reality, but you don't have to describe it, because the law has to be general. The notions have to be general, which are used in legal provisions. But you can't distinguish, you can't separate reality from law. Also, although, of course, law is the sphere of ought, and there are things which we want to achieve, but still aren't there. And so it is also a vision of future, what we want to create in this world, and this vision is written in the law. And if it is realized, if it is implemented, and if it happens, then we write new laws and want something else, something even better, even just, more just, if it says so.
Yes, in fact, a follow-up to this discussion. I mean, first of all, many thanks for your indeed so provoking presentation. And in conclusion, I will come back to the very issue how do we theoretize about law in our given societies. But my question to you is, just in reply to this question, saying that law, in a way, provides for the future. I want to challenge you, because, in fact, my understanding is maybe in the ideal society we could project our relationships, but we can't. And law typically encapsulates and reacts to human interactions, to human claims to rights.
Yes.
That was my quotation. So it will always be, law will be actually with a view to the past. You know, we hope that it will guide human interaction, of course, from now on towards the future, and certainly has that element. But I'm afraid to say that the laws we have right now, they in fact normativize our relationships of the past, our views of the past, and how we understood ourselves, let's say, some time ago. How do you reflect on that?
Yes, absolutely. Well, historical school of law. It says the law is historical. Pronoun.
Yeah, I'm sorry to agree with that.
And the content of law is created by history, by the experience of people, by past relationship. Well, there's I don't know, it isn't a tension, I believe, but it is coexistence of both of them. Because what is past and what is future, again. We are in the middle of it, and we can't be, and we shouldn't be free, if I may say so, free from past. We have to be.
That's part of identity.
Exactly. So there always will be some experiences from past, but they may change, because as we gain new experience, it changes, as well as our identity will change, and the future vision also changes. And that's why the law is dynamic. It's dynamic. It is dynamic. It's from past to future, and those are interlinked, and we can't avoid it, and shouldn't avoid it.
I believe we've started already quite an interesting discussion with at least 3 elements that can be separately developed, but we are bound by a schedule, so we most likely will continue the discussion. Now, we have to listen to what Professor Zena-Queen has to say.
Thank you very much. Thank you very much for the invitation to this beautiful country. It's always my pleasure to be here. And perhaps before we get my presentation on the screen, which it is already here, I will, before I start, I cannot resist but also to make comments to this ongoing discussion, because one issue, of course, particularly is related to me, and this is the participation of law professors in legal practice, and especially at the high courts. And I completely agree with Alina that it could be risky. It could be risky. It's very tempting for a law professor, for instance, to push some controversial theories, doctrines into the case law. And I know I'm trying to fight myself not to do this. Yeah? I cannot say that I'm 100% resistant to this, but I know some colleagues of mine who are basically writing articles with some very controversial theory. Then they will put it into their judgments, and then they will write a book where they will already say, this is the fact, this is the fact, this is the objective truth, this theory is valid, and they will quote the judgment. They themselves all there. So this is very problematic because legal theory, in my opinion, shall correct judges, shall provide them stimulus, shall provide them incentives, how to write or what to do, what not to do, develop doctrines. But if you mix up both, and if you are not aware of your distinctive roles, on the one hand, I can say something as an academic, I can write something controversial as an academic, but I shall not push it into my judgments, and I really try to do so. But if you are not resistant, if you are not reluctant to do so, it's dangerous, it's risky. Yeah, but I will start. Basically, I think it's good that I follow Alina's lecture because my first climb will actually follow what Alina said. My first claim is that legal theory is as national as the law that theory tries to explain. And on the one hand, it is clear that the law is never completely national, as you said, nor is it completely supranational, transnational. It's something in between. But my lecture, my introductory speech shall be more historical, and I would like to show that actually law in the path of the history is always moving from more national to more supranational, transnational connotation, and vice versa. So it's going towards supranationalism and backward. Nice example is Europe prior to 1800. Yeah? Europe prior to 1800 was a Europe which had not some complete national vision of the law. On the contrary, there was this, when you studied at universities, at the law faculties, you studied the same law, no matter whether you studied in Paris, Vienna, Prague, or Leipzig. Yes, you studied Roman law, or in Bologna, you studied Roman law and you studied ecclesiastical law, which meant that you can study in Paris and you can go back to Prague and practice law in my home country. And of course, the advantage was that quite often those legal studies were in Latin. So this was lingua franca, common language. So it didn't matter what was your mother tongue, because those studies quite often were in this universalistic language. So in that time, in this understanding, legal theory was indeed Europe-wide, and phenomena legal practice was dealing with was also Europe-wide. I have here an image of a witch hunt here. And witch hunt was a universal thing for both Catholic countries, Protestant countries. So witch hunt was happening everywhere, including Latvia, of course. So, and those practitioners who were trained in different countries could easily arrive in a different country and deal with the same legal issue, because quite often the rules were also the same, or they were only slightly different. Procedural rule, how to force them to confessions and so on. So this was the era when legal theory, emergent legal theory, was indeed Europe-wide, and those ideals were traveling from one country to another country. Today's legal historians say that there was some kind of use of comparative law, for instance. And in a way, legal education, legal studies in that time resembled me to some extent my legal studies in the United States. Yeah? Because when I studied in the United States, I studied at the University of Michigan, but I did not study Michigan law. I studied American law, or to be precise, some universal conception of what should be American law, and we gave some examples from Michigan law, New York law, but I did not study particular state law. I studied the idea of law, which is a common American idea of law, common law. And there was something like that in Europe, of course, prior to 1800s. Jus commune, common European law. what of course changed in the 19th century was this positivization, big codifications. When you create a big codification, which is a national codification, it's a national code of law, you need a national legal theory. You need a national legal theory which will be dedicated to explain the terms, the concepts of this national codification, and this is the time when the law for the first time is identified with a particular nation. Yeah, so German emperor famously said, we have one Reich, one empire, one people, and one codification, one law. So this was this idea of nationalization of the law, but on the one hand, I must say that in Central Europe, the idea that law is at least somewhat supranational did not die out. Because when, in Hungary, for instance, when they were writing new codifications of criminal law, criminal procedural law, in Austria, they always studied comparative law. They studied German law, Swiss law, French law, and tried to find out the best solutions. And the legal theorists, the legal academics, followed the path, and they also approached the law in this way, in this particular direction. So the idea of the law as at least somewhat supranational enterprise did not die away in the course of the 19th century. And at the same time, we can see that this was 1900 when there was the first Congress of Comparative Law, World Comparative Congress in Paris in 1900. Of course, in that time, comparative law was primarily comparisons of private law, because at the beginning of the 20th century, at the end of the 19th century, private law dominated legal discourse. If you are doing state law or constitutional law, you were outsider, you were a barrier, you got the worst office at the law faculty because you were doing something completely useless. But if you are doing private law, you got the champion of the faculty. Yeah? So, and obviously this Congress reflected this. After the First World War, things started to change. And, okay. Here you have a picture of Hans Kelsen. When big empires got dissolved, in 1918, I expected that actually this common understanding.
Back to the First World War.
Yeah, back to the First World War.
Back to Kelsen.
Back to Kelsen. Yes, Kelsen is here. When those empires got crushed, they dissolved, I expected that there would be completely isolated understanding of the law, but it was not the case, surprisingly, in the 1920s. It was the following decade which created a completely isolated self-perception of lawyers and legal academics. Because what was happening in the 1920s, it was a somewhat fascinating thing, because we got small states in Central Europe. Yeah, small states, Czechoslovakia, small Hungary, small Austria, small Baltic states, and but still, at least in the 1920s, the legal discourse did not cease to be transnational. And for me, what was fascinating was the beginning of the 1920s, Czech leading legal journal, there was a very important decision of the Czech Constitutional Court at the beginning of the 1920s, and suddenly on the pages of Czech legal journal there was a discussion of the most important European legal scholars, Léon Digois, Hans Kelsen, like the best French, the best Austrian, the best German scholars discussing this judgment. Unbelievable. And this was the proof that at least for the next decade, after the collapse of those big empires, the idea that the law is not isolated, it's not being hidden in a national state, was still around. What has changed was the 1930s, and I think the 1930s was the era of increasing increasing fascism, increasing far-right policy. And suddenly, far-right policy was, of course, isolating its law, its politics, within the courtyard of a national state. So in Central Europe, in the 1930s, basically parliamentarism, democracy collapsed almost everywhere. In Austria, in Hungary, in Poland, in the Baltics. Czechoslovakia was one of few countries where it somewhat survived. But for instance, Czechoslovakians did not want to compare anymore their legal conceptions with Polish or Hungarian or Austrian because there were fascists there. And fascists did not want to compare their conceptions either because they started to understand law as some completely purely national enterprise. So my claim is that this has changed in the course of the 1940s, and those were 1930s, which changed this understanding of the law. So the 1930s were the end of a long era when law was at least partly understood as a supranational phenomenon, which is going to be developed at least somewhat by Europe-wide legal theory. After the end of the Second World War, of course, again, something has changed. And what has changed? On the one hand, we got socialism in our region, and socialism was not the ideology open, friendly to making comparative legal studies. Even within Soviet bloc, it was not common to make a really decent comparative legal studies. There were, of course, in Czechoslovakia, there were some stupid ideas like the iron law of approximation of our Czech legal or Czechoslovak legal system towards the Soviet model. Yeah, there were things like that, but they were just mere rhetoric. There was no actual practice of comparison, of comparing the different legal rules. It was a bit different in the West. So, for instance, I have a quotation by Konrad Zweigert, who wrote in 1949 this idea of comparative law as a universal legal method of interpretation. So, of course, it was the reaction of what happened in Germany. We got here a picture of destroyed Berlin after 1945. And the Germans tried to get a new inspiration for their idea of law. So this supranational understanding of the law, together with the birth of the European Union, helped again to revive this idea of the law as at least somewhat universal phenomena, which must be studied at least by somewhat Europe-wide legal theory. After 1989, transition after 1989, yeah, okay. It changed the landscape. We got new constitutional courts. Interestingly, not only in this region, we got it worldwide. Yeah. So it's also in Israel. They did not get a new constitutional court, but their Supreme Court started to act as one in the 1990s. South Africa, they got new constitutional court. New Zealand, they started, or Australia, they started to act as constitutional courts. Their courts started to apply, so it was decentralized judicial review. And there was a need to, there was an obvious need to get inspiration from other countries, and this was a huge impetus for the revival of constitutional scholarship, which was becoming Europe-wide or even global constitutional scholarship. So this was an important thing which changed understanding of the law in our countries. I'm writing now a book with my Austrian friends. We are writing a comparative book how European constitutional courts are quoting their foreign counterparts. So how often the German, Austrian, Czech, Slovak, Polish Constitutional Court is willing to quote foreign constitutional scholarship and foreign constitutional courts. And we got the result that one of the biggest champions in Europe is actually the Czech Constitutional Court, because our numbers are immense. We quote a lot, and we quote really everything. We quote Latvia, as I will show you as well, we quote Latvian Constitutional Court, we quote really everything. And the question was from my colleagues that I shall explain it, because it's an edited book, so I shall explain it why we have such a different results. Because we quote much more often than Poles, or the Germans, or the Austrians. So it seems that somewhat this European understanding of constitutional law as a common project is getting solid ground in our case law. So my explanation was by this guy who is our president, former President Václav Havel, and the ideas of Charter 77. Czech dissident movement, one of the dissident movement which started as a resistance following international human rights treaties. So they resisted the communist regime following international human rights treaties, and for the dissident movement, human rights were by very definition supranational, international. They were not domestic. There was no domestic law which they would be interested in. There was international law they emphasized, they were international law they referred to. And my claim in this book, which is about to be published by Routledge at the end of this year, is that actually this is one of the reasons that the Czech court is even more outspoken and more active in this area of comparative constitutional law, because we take the idea that human rights are indeed universal rights, or at least Europe-wide rights, very seriously. So, let's go to the final slide, because time is running. So, final slide. So, is transnational legal theory taking over really the legal discourse, or is it just that we are imitating foreign models? Because you might also say everything what I just said about the development after 1989, it's too idealistic, that we are in fact just translating German books into Czech, or translating German case law into Czech case law, and in fact it's not a really Europe-wide legal scholarship, but it's rather, again, a wave of ideas coming from Europe's center to Europe's periphery. Because quite often, when we want to criticize ourselves, we would say we are periphery of Europe, we are always trying to catch with the West, and that's why we uncritically get all the ideas coming from the West to our legal doctrinal writings. It is a possible explanation. It is a possible explanation. I must say, I cannot say it's completely untrue. So some people say that's what I'm talking about. That's not really some single European legal scholarship, but it's rather law importation of the law from the West, please. But of course, the question is how we do that. So if we really just take everything from what they say in Germany or what they say in Karlsruhe and the Federal Constitutional Court as revealed reason, as ratio scripta, this is the truth because they said it in Karlsruhe, that might be the problem, because then we just pretend, then we just imitate, we just blindly repeat, and quite often my predecessors were doing that even in an invisible way. They just translated the entire paragraphs of the judgment from Karlsruhe, and they did not quote it. So you read something, it's Czech, it's very interesting, it's very smart, it's very sophisticated, and they did not even quote that it's from Germany, so no one knew. So my favorite example is when a colleague of mine, he wrote a dissertation or a habilitation thesis, when he was explaining what is a Czech way of constitutional complaint, Verfassungsbeschwerde, Czech constitutional complaint. He was quoting a lot in his book. He was quoting a lot of German literature. And one colleague of mine was writing like the opinion. He was the opinion about that book. He was criticizing the book that there is too much German quotation, but this is a Czech law he's writing about. So that guy was not aware of the fact that everything which the court, or not everything, but a lot of things which the court did in reality was just imitation or taking over from Germany. So if you do not do it openly, quite often the legal actors even do not know what's happening. They don't know that this is a translation of foreign models. What I actually try always to do in my practice is, of course, to take inspiration from Germany, but not only from Germany, from other sources as well, but to do it openly and not to follow it blindly. Yeah? So when I was a judge at the Supreme Administrative Court, for instance, there was a petition which basically claimed that it is unconstitutional if you have a minimum threshold in European elections. In Czechia we got 5%, if you are below 5%, you will not qualify to the European Parliament. And they quoted, the petitioners quoted, it's unconstitutional because it is said by the Germans. The Germans famously proclaimed there shall be no minimum threshold at the European election because there is no need to control the number of the parties in the European Parliament. That's why the Germans have got some crazy parties in the European Parliament, because they can get one deputy and he will make it into the European Parliament. But the petitioners were claiming this is unconstitutional because the Germans said so. And I was at the Supreme Administrative Court, and there was a discussion whether we shall submit the case to the Czech Constitutional Court, so they will annul our law because the Germans did say that our law is unconstitutional. And there was a decision 4 against 3. 4 judges were in favor sending that to our Constitutional Court. I was among those 3 judges who were against, so I wrote a very long dissent criticizing all this thing I'm saying here, that we basically shall not follow everything which what they say in Germany, because I personally think this judgment is wrong. It's not a good explanation of our constitution. And interestingly, the Czech Constitutional Court followed the dissenting opinion, and they rejected annulment, and they said they basically followed the dissenting opinion of our court. So I think this is the way how to do common European legal enterprise, theoretical enterprise. Not just to follow everything blindly, but to think it over, to analyze it. Is it suitable for us? Let's check other models. Not just take over one model, no matter how influential it is, the German model. So what we are trying to do is, we are really trying to quote all courts, and we are trying not to take emphasis only on the German legal scholarship. So you can see that we also quote English scholars, Polish scholars, Hungarian scholars, and yesterday when I was writing this PowerPoint presentation, I found out that at least in 3 instances the Czech Constitutional Court quoted also judgments of the Latvian Constitutional Courts, and quite even more often the law. Law is not always quoted in a positive way, but Latvian law, sometimes we quote Latvian law. Latvians are the exception in Europe, and we don't want to be the exception, and that's why the use of Latvian legislation is actually the argument to annul the Czech law, because it is like the Latvian one. We recently did it in a very controversial case. But in those 3 examples where we quoted Latvian judgments were examples where we said, look, this is a good interpretation not only of the Latvian constitution but also of the Czech constitution. Yeah? So in my opinion, this is the way how to do a common European legal theory. Not to take someone over, not to follow something literally and blindly, but to discuss and of course, also to meet and talk about those issues. Thank you very much.
Thank you. Well, I suppose that everyone here has this question, which Latvian law was quoted. Which was this infamous situation, if you may?
Yeah, but this is, I must say, it's a controversial decision. This is a controversial decision we made. This is the decision from the last month. All those cases I was referring to, I was not yet the judge. I'm a judge appointed in January, but this was a law about transgender issues. Yeah, and basically, Czech law has a condition that to change your gender, you must go to a surgery. Yeah, you must get castration. So you must get the operation. And we proclaim this as unconstitutional. And I was not a judge rapporteur, but I offered myself that I would do a comparative, 2 paragraphs of comparative law. So I found out that in Latvia you have a similar law, but this is actually European exception. Yeah, so I think it's Latvia, Poland, Slovakia, Hungary, something like that. But majority of the legal systems do not have this condition. So we said huge majority of European nations have a consensus that you shall not make a condition to change your gender to undergo surgery. And we quoted only a few European countries do have this condition we have in our law, and one of those countries was Latvia.
It's not a law, it's not a constitutional or judgment.
Well,
it was not.
Exactly.
Apparently, this is a topic where we could devote next year or the year after the whole topic about human dignity, about choice, and about the rules of nature, which leads me to inevitably the next question, if I may. I'm sorry, Anna, I'm sort of occupying the floor here, but I'm sure that this is just a warm-up for all the others who also have questions. Let me go back to one of your theses you started with. You said that the theory is basically corresponding to the law itself, which led me to, in a way, a question to crystallize what we call legal theory. Whether we say that legal theory is one general term, or we talk about legal theories, in plural, in a sense that when you talk about, let's take an example here, relevant example in Latvia, if you have rules protecting national heritage, either historic heritage or traditions, they most definitely will be based on what we call here metonica. That is the whole sort of area of science determining what Latvia is, what Latvians are, or in a way nucleus of Latvian nation. So that will be obviously emanating from the also national trends in philosophy. On the other hand, you might have the same heritage based on humanistic values that are pan-European, clearly. Let's say human rights. When we talk about rulings of ECHR, when we talk about Latvian rulings, and I'm dangerously close to what you described by the transgender problem, but when we talk about these pan-European issues, you most likely will not talk about national trends. We first and foremost will talk about issues that are relevant, at least on the continental level. Am I right that I'm assuming that what you are telling us is that there are different theories and more national theories when it concerns something purely regional, national, autonomous, and something that obviously is humanistic or supranational, when we talk about issues that are relevant to many nations, not just Latvians or Poles. So, am I right that we are talking about theories in that sense?
Absolutely, absolutely. Theories and when you say, for instance, in Latvian constitution, the importance of Latvian nation, on the other hand, the Czech constitution, and it's criticized, you do not have a reference to the Czech nation. Yeah, and you might wonder what's the reason, but there is no reference to Czech language, there is no reference to Czech nation, to Czech nationality, and you might say a lot of noble reasons, but I would say one very practical reason why we don't have such a reference, because there are only Czechs in our country, because we expel all of those others, or in many other ways they got eliminated from our from our country, and the last ones were Germans whom we expelled, 3 million Germans. So now we don't need to get those resources to the Czech nation, because Czech nation until recently was not in danger. So in this way, of course, the Czech national theory of national law will be very different, because it will be a different beginning of understanding what are basic constitutional values. But you are absolutely right. I was referring more about those universal human values, which could be universal to other nations, but definitely there are a lot of national theories as well, and there is definitely not one legal theory. So it was, of course, my lecture was a bit of simplification. I accept that.
Thank you very much. That opens up the gate for many other questions, I suppose.
Yes, we have like 2 there.
In this
Can I?
Yeah.
Yes. Thank you, Professor, for a very attractive presentation, very interesting example. What is your opinion? Is it really existing some soft law, or it's only some political issues, some white book? Is it still law, or it's something like political documents? Relation between hard law, real law, judgment, punishment, or some recommendation, white book, green book, and so many. Thank you.
You know, if we, of course it's a soft law. Everything I was referring to is comparative law. It's a soft law, it's not binding, it's not source of the law in this traditional explanation. But at the same time, I have the approach to broaden the concept of the law, including the soft law, including all this transnational law, because it gives, at the end of the day, more limitation on legal arguments. Yeah, so and more limitations on the outcome. So if I am a judge and if I'm bound only by the text of the national constitution, and I will take an account into the writings of domestic scholars only, then it gives me much more space to reach any result I would like to get. Whereas if I expand the notion of the law, and if I do not follow only national, domestic doctrinal writings, but if I also have broaden horizon, at the end of the day it will limit my possibilities. Yeah, so my favorite example is, this is the judgment which I was writing as a judge for the Supreme Court, and it was a judgment about constitutionality of the bylaw, which general courts can do. And a taxi driver, today it doesn't matter so much because we don't have taxis anymore, we have Bolt and all those stuff, and Uber, but it was a time when taxis were more common, and the taxi driver claimed that a fixed or maximum amount of the money he can charge a customer, maximum amount of money, is unconstitutional. And this is basically something the Americans will say it's in conflict with the freedom of contract. And there was indeed some case law in our domestic law about freedom of contract. So if I were a libertarian, I could even say that this law, which limits what the taxi driver can charge his customers, is unconstitutional. So what I did is that I made a comparative analysis, and I found out that if the Czech law is unique in any way, it is unique that we do not have fixed price. We have only maximum price. So a taxi driver can go below, whereas in many countries, in Vienna, in Paris, in Berlin, it's a fixed price. You cannot go up, you cannot go down. And so in this way, it actually, frankly speaking, I'm not a libertarian, yeah? So I wanted to achieve this result, I must say. But at least I found out that this is not just my idea, that I believe that this sort of price control is correct, but this is something which I can support by transnational considerations, I even quoted by some economic analysis of law, and there was a very interesting analysis what happened when this taxi market in the United States was deregulated in the 70s, and the result was remarkable. It completely destroyed taxi market. Yeah, so cab market. So if you expand the law in this way, of course it's not a law proper, but the law proper gives you a very limited answer to what is the law. So if you expand the notion of the law in this way, it's of course more demanding, it's also risky that you might make a mistake, but it limits, at the end of the day, it limits the judge's will.
Please, Ines.
Thank you so much, Professor Kuhn, for your presentation. Since the title of the discussion is also Common European Legal Space, I believe that nowadays, due to the growing synergies between EU law, European Convention on Human Rights, and national constitutional law, this Common European Legal Space includes not only horizontal dialogue between national constitutional courts and this comparative constitutional reasoning where constitutional courts refer to each other's case law, but it also includes the case law of the Court of Justice and the case law of the European Court of Human Rights. I would like to ask a question from the perspective of those supranational courts, for example, from the perspective of the Court of Justice of the European Union. We don't see very often in the judgments of the Court of Justice that they refer to the case law of national constitutional courts or use this comparative constitutional reasoning. Do you think that it would be helpful if they do so, for example, to kind of promote cooperation and mutual understanding in this area of synergies between EU law and national constitutional law?
European Court of Human Rights is referring to domestic case law. They always have, if they have some important case, they have always this part which they call comparative law, and they refer to domestic case law, they refer to transnational case law, they even refer to the literature. But you are right, Court of Justice does not do that. Yeah? But I think it's difficult to say that they should change their practice because their quotation practice is simply different. Yeah? It's some kind of mixture between a German tradition and French tradition, and their legal reasoning has always been traditionally closer to French tradition. So if they are close to French tradition, we might be happy that they quote their own case law. Yeah? So if they were really loyal, faithful to French tradition, they will not even quote their own case law. So I would be, of course, happy if they quoted more sources, but that's their way how they do the things. Yeah, so it's difficult. They don't have dissenting opinions. Simply, this is a different style of the court, still influenced by the French tradition, and they have their own, of course, justification why they are doing so. They have very short terms for judges, renewable terms for the judges. So if you open the gates for more sources, you might also say that you are getting, that legal discourse is getting a bit more politicized, or there is a risk, a threat of politicization. And I think this is the reason why they stick to a very strict rules, what they will quote and what they will not quote.
Right, so given that there are no more questions, I think we can move on to the third presentation of this morning session. Please.
Yeah, thank you. The question is how national is or could be the legal theory in European legal space. I will narrow this question to the question how national could be the state law, constitutional law, state form, state model in the European legal space as a more precisely for a member state of the European Union. And therefore, I will start from the point of view of the European Union and I will ask which model of state, of constitutional law, of legal theory which is linked to the constitution, is compatible with the structure of the European Union and European Union law, also from the point of view to the national systems. And we can see that historically, European Union was founded as a union of 6 democratic states by coincidence. Those 6 democratic states all have the same democratic state system. There was no one which was outside the democratic system, and this question was not problematic. And then, with new member states, new member states, there arises a question: which kind of state we can admit? That means already existing European Union. Which kind of state we can admit to the European Union in order to be a benefit for the Union and not to destroy and not to create conflicts. And the criteria was set first time, and then more precisely, but the first time 31 years ago, Copenhagen criteria 1993. And the Copenhagen criteria in principle 3. This is constitutional democratic state. This is we could name this model constitutional democratic state. Constitutional, that means that rule of law and hierarchy of norms. And very important question is, or point is, that the hierarchy of norms is controlled by independent courts. If there is no control of hierarchy of norms, that means the rule of law is not working, I would say. And soon after that, there was also the question, because all Central and Eastern European states, after the change of the regime, established constitutional courts with very wide competencies. But some other old member states, like the Netherlands, for example, they have not. And also Scandinavian states have no constitutional courts. And the legal theory discussed it, and it found it's enough not to have constitutional court, but if there is some kind of decentral constitutional control by ordinary courts. It's enough. So it's principle constitutional state. Then democratic state, that means relatively easy to answer. All state decisions should be within the chain of the democratic legislation and free elections and so on, so that all decisions are democratic legitimate. And the third element was fundamental rights, and I will explain that. It's clear. So, and the legal theory of all the states, member states of the European Union, of course, is closely linked with the state form, state system. And we can see that in our states that the legal theory completely changed 1990, 1991 after the change of regime. So to say, the legal theory is following the state. And legal theory explaining and shaping and the state model. So that we have a common European model of state, and that means also the common European model of legal science in this area, I would say. I will exclude private law and so on. In this area, constitutional law. And but of course, we have not a one role model. For example, German model. So Germany and all states should be more or less similar to Germany or to Sweden or to Czech Republic. So we have a common model as a set of core principles, But we have 27 varieties of this model, and all varieties are equal. This is very important because the European Court of Justice is using this term by jurisprudence, common constitutional traditions. Common constitutional traditions is exactly the references to the 27 varieties of the state, of the common state model. And why we have 27 varieties? Because it lies also in the constitutional theory that the constitution of each state always reflects the history, the political history, but also the history of ideas. And this is all reflected in constitution directly, also in the text, or indirectly by the interpretation of the text, application of the text. And we have 27 histories of the states, of 27 states, and therefore we have 27 different constitutions, but we have a common model. And the question arises, this is a political question and also a legal question nowadays, is whether the particularities of a constitutional variety of the same model is still within the common model or already outside. And we have this question because I said already at the beginning that the European Union was founded by 6 states which very common understanding what means democratic state, constitutional democratic state. And Copenhagen criteria were applied to the new member states which were admitted, but there is no complete, so to say, very clear regulation. What happens if one member state, old or new member states, founding member state, afterwards, after the member state is already within the European Union, what happens when the particularity of that state model is moving away from the common model? And we see this in some member states with some authoritarian tendencies. And I think this is a question, of course, for the European politics, but it is a question also for the legal science, for the law, for the practical law of the European Court of Justice, and of the practical jurisprudence of the national constitutional courts. I would add also that if one member state is moving away from the common model, it is not only a question for this member state, which is moving away. It is a question of the 26 other member states, because the European Union structure and European Union law can work properly only when all 27 member states, for example, rule of law, is functioning in all 27. If in one member state is some interferences, some problems, then of course all 26 other member states are also is problematic for the other member states. And therefore it's legitimate to question how we will preserve or develop our European Union in such a case, such a specific case. There is, since Treaty of Lisbon, one not very effective mechanism in the Treaty of the European Union. It's Article 7. Article 7, I will not quote it, you can read it, but it serves common action of the 26 other member states is the one condition, and this is a very complicated, but I think justly complicated procedure in order not to apply Article 7 for some political reasons. I think Article 7 is very thoroughly formulated. But if there are 2 or 3 or 4 member states, of course, this is a more difficult problem. There is no answer in the European Union law, and therefore it is already since several years discussions in the circles of European Union lawyers, also national constitutional lawyers, how to do in this case. I said in an article a few years ago that Article 7 is enough, because if there are 2 member states, 2 to 25, it is already, this is not more a moving away of one member state, but this is a political division of the European Union, and maybe it could be 20 to 7 or something like that. But we should find an answer how to do when there are several member states, but until the common law now, it is necessary, it is possible that this 1, 2, 3, 4 member states can hinder the development of the other member states. This is a real problem. Not that in one member state something happens, but they are hindering, for example, if member state A is moving away with the system from the common model, then it's a problem for Latvia, Sweden, in Germany, and Czech Republic. We cannot move away. This is a problem. And therefore, we have discussed also in the court, but rather in scientific circles, how to do with that. There are several proposals in several ways, and I think we will see that also the politics will deal with that sooner or later. We have no more time, but I can say there are a few models. For Article 7, it's clear, but it means Article 7 means 26 to 1. But if there is more than one, then the extensive use of existing instruments, for example, enhanced cooperation. We have this article in the Treaty of the European Union, is used seldomly. But I think it's a good instrument. In many cases, the problem could be solved by using the instrument of enhanced cooperation. Then, of course, there is a very interesting, some cases we know, also actually, it's, I would say, by the European support to Ukraine, that the member states are acting, the willing member states, this is a notion, the willing member states are acting outside the treaties as states. Also, this is also a possibility. And of course, the interpretation of the extensive interpretation, I am stressing the word extensive and active interpretation. We discussed yesterday or the day before yesterday the court activism, so to say, but active jurisprudence of the European Court of Justice which can develop this interpretation of European Union law. And we can see already that the beginning of the way of the European Court of Justice as a European Constitutional Court by the case Jesus Portugueses 2018. It was unthinkable before. But now it's already this path is open, and I think the court could go this path away. But this is also my personal opinion, if the court is doing so and more active and extensively, then I see a certain problem of legitimacy of the European Court of Justice for that. And there are also several proposals, but the core of these proposals, also in scientific circles, I would say, the core of this proposal is that the European Court of Justice consists, of course, of 27 judges, each from each member state. But they are not reflecting or not advocating the national point of view. They are advocating the European point of view. And if we would develop this European legal model, European legal model, it could not be done only by the European Court of Justice. And there are several models. For example, expanded forum with 27 judges of European Court of Justice plus 27 judges from the member states, from each one, which would reflect the national point of view, the point of view of national prosecution. I think there are several ideas, but it seems that we cannot avoid this discussion, legal discussion, and also after a certain time, or already now, a political decision of this issue in order to keep European Union effective and moving. Thank you.
Thank you, Gilead. I think you've already determining certain policy issues in relation to an imminent crisis that we are facing, as an example, with the position of Hungary and a number of joint issues, or
I mentioned state aid for X.
I see. Yes. Well, let's keep it in that context as long as we are on air. But frankly speaking, my immediate question is there no necessity to develop a theoretical background, a doctrinal reason why there is this overwhelming majority? And then there are these rogue opponents who are opposing, not because of the, let us say so, some high ideological aspects, but rather practical interest aspects. And some of them actually are frankly using it as for the bargaining purposes, so that to get a better deal, a better chunk. So it is purely selfish approach in some of those aspects. They may, of course, come up with statements of national sovereignty and so on. But my question, to summarize, is do we not need a doctrinal aspect, which would obviously be a pan-European value-based doctrinal aspect for these moves that you have just described?
Exact, and such kind of doctrine is developed. There is no formally legitimized organ or forum which can do it. It is an ongoing discussion in the European law conferences and so on. But concerning the problem of the motivation for this opponents to the common system, there are two cases. One case is a purely egoistic case. So that in order to get something in another case, they are saying we are vetoing case A in order to negotiate better position in case B. I think this is a clear misuse of the sense of the European treaties, and this is for the European Court of Justice to say clearly this is not a use of the right to veto, but a misuse of the right to veto. This is one case. The other case, if there is already ideological and principal differences, then of course the question arises, do we as 26 or 22 member states want between us such state with such values, with such ideology? Like here, for example, how to organize a just procedure to exclude from this circle one person. or to make him to hinder this common decision of others. So, and this is a question. I think this is a political question. Also, we have two kind of questions. One, misuse of the veto, clear judicial issue, and I think it's for the European Court of Justice it could be done. And of course, the second question is, for example, if one member state became authoritarian, most of the member states of the European Union, 23 from 27 member states of the NATO, and NATO, despite the preamble that it's one of the goals is to defend democracy, it was not explicit Union of Democratic States, because from the beginning it includes Portugal, which was authoritarian state. And also it functions well because it was already included in the structure of the NATO. There was not necessary to have democracy or rule of law in NATO states. And if I am correct, then also Greece, which was authoritarian state between 1964 and 1974, was not excluded from NATO. So, NATO can function. Yesterday, I explained, also United Nations also can function with different systems in the state, but not the European Union. The European Union can function properly only when these three elements, constitutional, also rule of law, democracy and human rights are functioning. Also, for this reason, it is in the interest of the European Union to look that the member states are all within this common model, with, of course, quite several differences, and the differences could be very different. And the only criteria is whether the difference, also the particularity, is compatible or is not compatible with the common model. For example, you already mentioned we have in Latvia the question of state language, national identity. It's the core of our constitution. It is completely compatible with the common model. It's not contrary. If we would have some system or even practice that the courts would be not independent, that would be contrary. This particularity, we cannot say, oh, it's our national particularity, not independent courts. It's not compatible. Also, the criteria is compatibility. And with this compatibility and with this model, there is a wide autonomy of the member states in shaping the constitutional system, constitution. And of course, it's absolutely legitimate because we have different history and we are all products of our history and we cannot deny that. And I think this is some kind of application of the principle united in diversity. Thank you.
Thank you for the response.
I will take the next question, Minister, but I think my question is kind of similar to others, so sorry, I will put it in front. Well, my question is similar, but I do not touch upon the Article 7, but it's much broader. So if there is a common constitutional tradition, and how do we separate which is just a deviation from the tradition, which is something as a new trend? Let's say one of the countries adopts something very radical in the field of climate law. So would we say that this is the deviation or breach of other human rights, or just the beginning of a new trend or a new cycle, beginning of the constitutional development?
Yeah. Yesterday we discussed the problem of political content of judicial decisions. We cannot deny that in judicial decisions, especially constitutional court, also some political content in the shape and the form of judicial decision, judicial opinion. And of course, whether something is defined as something new or a deviation, it is by systemic approach and by other, as I say, by our interpretation methods possible to narrow this field of decision. But anyway, always there is left a space for the judges to decide accordingly to their conviction, accordingly to their biography, I would say. And we cannot deny that. It's, of course, this sterile approach that judges are always neutral and so on. It's socially not true. We should admit that and include in our theory. And that means that it is up to the forum which would decide on that. Maybe European Court of Justice. My preference would be European Court of Justice plus representatives of national constitutional courts. So by discussion, whether we are seeing that as a problem for preservation of the existing situation or admitting something new. You spoke here about gender issues in constitutional form. Of course, preservation of the family in classical sense mean, oh, this is a deviation. We should not admit that. But the judges said, it's not a deviation, we are widening the definition of family, and both approaches would be just, I would say, also legally just. The courts decided in this way. So I cannot say that there is a specific rule. There are rules which narrow the space for decision of the judges, but always the judges have more or less space for their own conviction and opinions. And therefore, the composition of the Supreme Courts are very, very important. The composition, also their political mind, their social mind, and so on. Yeah, thank you.
I see that we are already going into the sort of coffee break, but if we could still have these two brief questions by Professor Ivars Ieaps and also by Ines.
Well, I just wanted to say that you're completely right, Egils, on what you said about Article 7, but I should emphasize that the European Parliament initiated during the previous convocation the so-called the rule of law mechanism, which is intended to solve some of those problems. Some might ask, well, but what a legitimate interest do Latvian state have about, well, internal proceedings of Hungary? So, well, this is a reasonable question. And the argument we provided is, well, those elected governments are deciding on the European budget. And this affects all of us directly. And if a particular government, let's say in a country X, Y, or Z, is not elected in a proper democratic procedure, it directly also affects our life. And this was the argument provided, and that's why the initial procedure was that we just wanted to cut the funds for those countries that are transgressing the basic rule of law issues. At the same time, of course, well, legally speaking, we went a little bit too far, because what we said is basically that rule of law also includes a proper democratic decision-making. Well, there's free elections, free media, free speech, and so on and so forth. This was an argument which we really provided, and I hope it still works, but I think this boils down to the question, what kind of entity is the European Union itself? is. To what extent is European Union a democratic polity, if you want? Because how the European Council makes its decisions, with all those veto powers, with a completely closed procedure. This is what we as directly elected representatives in the European Parliament really find as a basically undemocratic way to organize our common life as Europeans. But what I just wanted to emphasize, and I would really like to have your reaction on that, is that we did something. The rule of law mechanism is here, and also those rule of law reports coming in yearly, which is, to my mind, a step in the right direction.
Yeah. Also, the other instruments, you are absolutely right, there are different instruments, also the rule of law reports with the Commission and the rule of law instruments, and so I have not expanded this part. But you're concerning the democracy in the European Union, not in the member states, but of the European Union. You put a classical question and I will give you a classical answer. So, the European Union is not a state, but we know from how the democracy is organized, elections, parliament, government, and the state administration, which is part of the government. Also, this applies to the state. But the European Union is not a state, and democracy can be organized in such sui generis structure as European Union in a different way, which is appropriate to this specific structure sui generis. If we would do that in a classical way as in the state, parliament with all the rights of the parliament, what you want, also responsible government and so on, then the European Union will mutate, would be a state, a federal state. But the member states and the voters in the member states don't want to have, for the moment, European federal state. So this is the reason that the democracy is organized in a different way, which reflects to something like a federal, which two aspects. The common population, which is represented by the parliament, and also the different states, which is represented by the Council of the European Union. It's something similar as in United States. There is a House of Congress, all population, and of course Senate. 2 senators from each state, independently from the size of the state. And something like that also in the European Union. Therefore, I think this common argument that the European Union is not organized democratically, then you should ask or answer yourself, do you want a European federation? Or you will leave by that. If we are answering, this is a purely political question. Do we want Eiropas Savienotās valstis? Yes or no? And then if you are saying yes, of course, then you are right, and then we should reform the European Union democracy, the European Union in such a way.
So, thank you. And then from Ines, because I'm really looking at the watch.
I will try to be brief. My question is about different point. We are talking about national and constitutional particularities in this common legal space. And I think we are too much concentrating on these abuse cases, abuse of EU common values and those rule of law cases. But there is also, I think, need to focus on how do we define common constitutional traditions and what are the common constitutional traditions and how we distinguish this concept from national constitutional identity under Article 4, Paragraph 2 of EU Treaty. What is in the relationship between those concepts and how do we interpret those concepts in this common European legal space, which I think are legitimate uses of these constitutional practicalities. Maybe your short comment.
You are completely right. Because the European Court of Justice is using this notion, used already a long time, in a rather, it's my critique already as a judge there, and I think in it too, in a rather superficial way. And therefore, we nationalized, and when you were President of the Constitutional Court, in Riga was a specific conference on this issue. How to evaluate the common constitutional traditions. Because in the European judgments, this notion is used, but in a superficial way. Also, I would say there was no thorough factual evaluation in all 27 member states. It's maybe also a case of capacity of the research department of the European Court of Justice. But also this notion was not so to say, theoretically deep enough evaluated. And I think we are doing so, and we are moving forward in this respect, also because of the Latvian critique. I assume that now it is a little bit better, huh? Yeah? Okay.
Well, indeed, on that one, we're moving into the third meeting already, which will take place in 2025 with the Bulgarian Constitutional Court, and also with the Constitutional Courts, and the Court of Justice will be there. And that is, in fact, that format, you were suggesting that there should be both sides represented and building the common theory, if you want, the Court of Justice and the Constitutional Court, which are the main actors behind the common, at least constitutional law theory at a supranational level. But I would like to add 3 points to what Ivers mentioned and you replied. If I may, the definition of the meaning. If you look at the conditionality judgments of 16 February 2022, there in those judgments, the Court of Justice very clearly defined what union at this stage is. And the union is a common legal order which is based on common values. The values are stated in Article 2 of the Treaty on European Union. That's what union is. It's a common legal order which emanates from common the values that we share. Nothing more, nothing less. Next, what it means, Article 2 contains the value of democracy, which has been concretized in several provisions of both treaties, Treaty on the European Union as well as Treaty on the Functioning of the European Union. And from those articles, whether it's Article 20, 10 or 22, a particular model of democracy emanates, and that is participatory democracy, and that is where I'm linking to the elections, direct elections to the European Parliament, but also direct elections among EU citizens at the municipal level. Now, the sad point is, of course, this is still something that is very new in the world. Europe is the first one experimenting with this type of common legal order based on values, and that requires indeed its own legal theory, which most likely indeed stems from what is common to us, as you've discussed so far, but also what is different. And that's what makes this common legal theory for the Union possible. But that is a work in progress.
Thank you, Linda, also for the response to some extent to Ivar's comment from the legislator's point of view. And with this, I would like to thank all the panelists of the morning part of this today's session, and I would like to ask for a very, very brief coffee break because we are already running out of time and I'm getting nervous. You know all Arvid's, how he will come in and he will stop any discussion, irrespective of whether we have conclusions or not. We have to respect time set by Arvid's, and we have to also, we have very interesting presentations by 4 other panelists. So let's just go for 5 minutes and really start this.
see everyone back here, at least from the speakers, so that we can present the remaining speakers. And I hope that we'll have more people joining while we start. First of all, again, emphasizing the importance of the debate that we have here, and I'm certainly very happy to see the variety of representatives, not only of the Baltic region, as we traditionally have had over the years, but also of Central and Eastern European countries, because clearly, when discussing the framework of the European Union and notion and also element of each of the national states, we see that there are divergences and there are differences how states come in with respect to what Nicholas Davids emphasized, common values and common sort of frame in which we operate still. There are these national differences, and therefore I'm pleased to present 4 other panelists. To start with Tomáš Gabriš, who is professor at the Nava University, and you are also a member of Slovak Academy of Sciences, specifically in relation to the Institute of State Law. Correct. This is exactly where we are now concentrating. The next will be our great neighbor, Professor Gabriel Davids, from the University of Tartu. And then Tomas Bergmanas, another of our wonderful neighbors of Lithuania, the University of Vytautas Magnus in Kaunas, and as a conclusive speaker in this section will be our dear friend and also one of the, so to say, old members of this community of ENG, Yanis Plebs, who is again sitting on 2 chairs, if I may say so. You are both the Senator of the Supreme Court and Minister of the Department, and also you're one of the active, and I would say most of the ones who is most fruitful in writing about constitutional law, about state law, also lecturing for students in the Department of Theory and History of Law in the University of Latvia. So with this brief introduction, I believe we can move on.
So, please, we will give floor to Tomáš.
Yes. Thank you very much, ladies and gentlemen. It is my pleasure and honor to be here. Thank you very much for the invitation. Thank you very much to the organizers. I'm really looking forward to this topic because that's something that, well, I was thinking about recently quite a lot. About the future of the legal theory in the European Union and the future of legal theory in our law schools, but at the same time the role of the legal theory in legal practice. So basically I will start a little bit with the legal history or the history of legal scholarship, history of legal doctrine, and I will start with the history of legal theory as such, as a separate discipline. So we already heard about some history of legal theory by Zdeněk Kuhn, and I will basically continue or elaborate a little bit on his thoughts. And that's basically the idea of how the theory of law as a separate branch or discipline of legal scholarship emerged. So basically, this may be familiar to you, so this may be no new information to you, but basically, since the beginning of the 19th century, since abandoning the idea of natural law, which was basically the underlying concept of law worldwide. So that means there is some reason that we can uncover in the nature, and the law is based on this natural law, natural principles. When this was abandoned in the beginning of the 19th century, of course there was a search for new underpinnings, new foundations of the legal scholarship, and new foundations of law as such. So the legal scholarship or the legal disciplines, they needed new underlying concepts. So basically they were in search for something that we have in common or something that can be considered common root of the legal scholarship and of the law in various countries. Of course you can do so in a formal way or in a material way. So that means you can either try to uncover some value-free principles or rules, methods that the law is using, and that's the formal aspect to the legal scholarship and formal aspect to the legal science, something like the normativists were doing in the beginning of the 20th century. That means trying to find some structural relations within the law as such. But that's the formal approach to legal scholarship, and that's the formal way how to find these common roots of the law, so the law has some common structural aspects worldwide. The other approach that was taken in the 19th century was rather the material approach. That means to try to make some abstraction or generalization of the national institutions of law. And this material approach to legal scholarship or legal science is precisely the way how the legal theory, as we know it nowadays, emerged. So we have the first theoreticians, or at least according to Professor Funke from Germany, the first legal theoretician is Ernst Rudolf Bierling, who wrote his book on Prinzipienlehre, that means the doctrine of principles. And his approach was precisely trying to find some underlying material concepts of law. Something very similar was done also by the Anglo-American legal scholarship. In the same time, Sheldon Amos has written a book which was published or edited numerous times, and it was called The Science of Law. And again, its content was basically making a comparative undertaking, trying to distill from all the legal systems worldwide some general substantive sentences saying that in each legal system you have some contracts, you have some obligations, you have some liability, you have some damage. So these general material concepts were uncovered by these first legal theoreticians. So, but again, this is being heavily criticized, and it was heavily criticized already at that point, saying that this is not useful for the practical lawyer. Why do you need to know that there are some universal principles, or there are some universal values, or universal contents, universal legal institutions worldwide? So this does not help the actual practitioner to know that in some countries the damage has this definition, when in your specific legal system the definition is a little bit different. So that's the point when the legal theory in this universal worldwide approach was rather replaced by the national legal theories in the 20th century. Again, in the same way, by the same methodological approach, by induction or abstraction, generalization of the national legal system. So that means you take all the branches of law that you have, and in each branch of law there is some liability, there is some damage, there is some personalities, entities. So basically you make an abstraction of your national legal system. We didn't have that in our territory in the first half of the 20th century, because basically each discipline, that means civil law, criminal law, administrative law, they were developing their own theory. So we did not do this undertaking of trying to make some generalization. This has arrived to our territory rather after the 1948. With the arrival of the Soviet textbooks on legal theory. So we had a book translated in 1950 by Arzhanov and Kechekian, and Mankovsky and Strogovich, the Russian Soviet authors. And basically they have introduced this idea of legal theory in our territory, saying that this is the generalization of all the substance of all the various branches of law. And it could have been some backbone of the legal system, by the way, because at the turn of the 18th and 19th century, this role was played by the civil code. So the civil code was the backbone of the legal system, so all the definitions, basic definitions, were there in the civil code. But in the 20th century, with the arrival of the public legal disciplines, the importance of the civil code gradually shrank only to the main code of the private law. So it did not play this role of the backbone of the whole legal system. So maybe that's a hypothesis. The legal theory could have served this purpose, both in the scholarly terms as well as in the educational or pedagogical terms, because this backbone of the whole legal system was being taught to the students in the first year of their studies in a sort of encyclopedia of law, that means the general notions as a sort of an introduction to law. This approach was really applied in our territory in Slovakia, and to a great extent it still holds in effect in Slovakia. So we still have this further developed Soviet or socialist approach to legal theory for the students in the first year. But of course there was some evolution, and what I'm going to offer here is an overview of this evolution. So what were the new topics that were added, and what are the current topics that we are dealing with now? And I will continue further on claiming that these new topics are basically the topics that have to do with legal methodology, and this is the actual topical problem that we are facing nowadays, and that's the problem that we are facing not only in Slovakia, but these methodological issues, either with respect to European Union law or to our national legal systems, is something that we share, and this will be the idea of the common European legal methodology built upon the classical legal theory. So this was the textbook from the 1950, the translation of the Soviet textbook. So basically it was about the concept of the law, about the sources of the law, legal relations, compliance or behavior according to law or against the law, and the structure of the legal system. So these chapters were basically the chapters which established the tradition of legal theory in our territory. Of course, you have to take into account that there was the theory of state and theory of law. So one semester was devoted to the theory of state and the other to the theory of law. And then in the following years, there were textbooks authored by the Slovakian authors themselves. So we had a textbook authored by a professor, his surname was Donchak. So he wrote a book in 1974, and he elaborated on these topics, and he added new topics. So I prepared some comparison. To the left, you see the topics that were dealt by the legal theoreticians in the era before 1989, and then on the right you see the topics which were dealt with after 1989. If you go from the bottom up, you see that there's a lot in common: interpretation, system of law, adjudication, legal norms, legal relations. What has changed quite naturally was that the socialist legality was replaced by the rule of law principle. I mean, the idea was basically the same, but the application was different in the socialist era. The sources of law, the topic remained. Of course, you have the new problems with the new sources of law, soft law and judge-made law. You have the relationship to law and other normative systems. What changed and what was not emphasized that much was the relationship between the law and society. These empirical approaches that were very popular in the socialist era, and they are still very popular in Western Europe, they were abandoned after 1989 in favor of rather talking about the relationship between law and the morals. So it was in a different clothing, but basically the same problem. And of course, the nature of the law, what is the objective law, what is the subjective rights, what is the actual normativity of law. And this has replaced the former attention being paid to the methods of law and legal scholarship. This was not developed after 1989. I'm not really sure why. I mean, of course, the methods of law and legal scholarship before 1989, they were basically based on the dialectic materialism. That means that you have some Marxist-Leninist methods in the law and legal scholarship, and probably people didn't know after 1989 what to replace these Marxist methods with. So nobody actually was thinking about the methods that the legal theory or the law as such or legal scholarship is using. So they simply abandoned this topic in the textbook after 1989. So when speaking about the new topics that we have introduced after 1989 and recently after the year 2000 mostly, first of all, it is of course the topic of the rule of law. That's something that is very popular. Even the World Congress of Legal Philosophy, which has taken place in South Korea this year, the main topic was the topic of the rule of law, so it is still very topical. We introduced new topics to legal theory, which basically maybe would better fit into legal philosophy or in other branches of law. So there is still not a clear distinction between legal philosophy and legal theory in this regard, because we are discussing topics as law and power, law and justice, law and culture, globalization issues. So these are maybe topics that would be closer to legal philosophy, but very important aspect having to do with the abandoning of the formalism and introducing the fact that the law is basically argumentative, so it's about the arguments. So we focused on the topic which was previously neglected in the theory of law, which is the argumentation theory. And of course the creation of law, legislation, the theory of legislation, problems with the effectiveness of law. In the communist era, the law was enforced, sometimes violently. In the democratic era, there are different ways how to ensure the effectiveness and validity of law, with different types of sanctions and liability issues. So these were the topics that emerged after 1989. And again, we tried to focus on the comparative law. Of course, there were some traditions even prior to 1989 about the comparative law, but of course it was in a very negative tone before the 1989, saying that the capitalist law is not correct. So now we reassessed that. So these new topics that are emerging and re-emerging, resurfacing nowadays, the current ones that we are discussing now in these days or these years at our law schools are basically, again, the return to the question of the legal science, which was abandoned in 1989 in the textbook. So we are reconsidering what type of science is the legal science. Is that science at all? What are the methods that the legal science is using? We are discussing the values in law. You have the German Wertungsjurisprudence, the teaching that the values in law are important in comparison or in contrast to the value-free ideals of scholarship in the first half of the 20th century. And we'll discuss the judge-made law and of course the influence of international law and European Union law. They have different sources, they have different methods. So the international and European Union law is posing challenges to the traditional legal theory, the traditional theory of legal sources, of the legal system, of the legal structure, of the hierarchies. So all these issues are discussed nowadays, and basically they are methodological issues. So if you take into account all these major aspects, they are basically aspects how to apply law, how the judges should act in current days. So these methodological issues have led us to the attempt to revive the problem of legal methodology. So it was really, after 1989, it was neglected, and currently we reintroduced new courses at the law schools, especially at our law school in Canada. We have established various subjects, one focused on the methodology of legal scholarship, legal science, and the other focused on the methodology of law as such, in order to differentiate between that, and in order to, create a new theory of the methodology of law. Of course, one could base that on the German tradition, because the Germans, they have their tradition of the Methodenlehre, but this tradition is basically focusing very much on judges. So their law on education of lawyers is basically the law on education of judges. So what they do is they only teach the methodology of adjudication, so how to apply the law by the judges. So they are not teaching how to create law, how to act as a legislator, how to comply with the law, how to act in accordance or in breach of the law. So this is just to show you that what's approximately the contents of the courses that we are teaching. So in case of methodology of legal scholarship, we basically try to situate the legal scholarship into the overall broad picture of the sciences. We claim that the dogmatic legal scholarship is basically humanities, not social sciences, but humanities, because you work with the text and you interpret the text. You argue, so your argumentation or hermeneutics is much closer to philosophy than to social sciences. Of course, you are also doing empirical research, so we also say that it depends on whether you are doing dogmatical research or whether you are doing some empirical research or interdisciplinary research, legal history, legal sociology, legal psychology. Then you are using, of course, different methods. So we are trying to explain to the students that there is different methods being applied by lawyers themselves when they are applying law, applying dogmatic to the actual cases, and on the other hand, something that the legal scholar is doing, because he can both do the dogmatic legal scholarship but also other types of scholarship. And there is differences in argumentation, interpretation, and of course, we place very much emphasis on the ethics in legal science and ethics in the methodology of law. So that much to the methodology of legal scholarship, and then we have the course on methodology of law, which, as already mentioned, is not focused only on the methodology of adjudication, but also on the methodology of legislation and methodology of compliance with law. So, and we very much emphasize and stress that there is probably various methodologies being used by various branches of law. Because you have different methodology, or somewhat different methodology, using in case of public law disciplines, private law disciplines, even various branches of law. So one has to take this into account when speaking about the methodology of law. So one should not be reductionist and saying there is one methodology for all legal branches and for all the disciplines. Of course, we have the challenges of the sources of law, the challenges of the hierarchy of law in the post-positivist era. This is something that we are touching there. Speaking about the methodology of legislation, then speaking about the methodology of adjudication, that means how to fill the gaps in the law, how to interpret, so what is the actual sequence of, or the order of the interpretation methods, if there is any order, if there is any order in argumentation methods, how to argue, so what type of argument is being preferred. And again, the ethics of legal interpretation and argumentation, if you can whether you can lie as an attorney before the court or not, so these are the topics that are very popular with the students. And finally, we end up with the methodology of compliance, that means misuse, abuse of law, violation of law. People basically what types of misuse or abuse of law there are, and what is the relationship between the contracts and the law. So what if the law changes and you have a contract which was signed before, the law has changed, what's the mutual relationship, and how to interpret the contract, and how to interpret the testament. So this is something that we are basically doing there in this methodological course. So, and these are problems that all the national legal systems are facing. So when I was speaking in the beginning about the material and formal approach, material approach says that, yeah, in each country may have some different contents of the legal institutions, different rules, but the problems that the legal systems in Europe are facing nowadays are very much the same. Very much the problem of filling the gaps, very much the problem of the order of the interpretation methods, types of arguments, what is to be considered a legally binding source and not. So these formal issues are something that we are sharing, and we share that at the level of the national legal systems. But at the same time, and this is important to realize, we also have the European Union law. And you can take both formal as well as material approach to the European Union law, because the European Union law can be, again, there can be created a legal theory of European Union law. That means this abstraction of the legal institutions can be made. So the both material and formal approach can be taken with regard to the theory of European Union law. And of course, there is huge opportunity to develop some comparative legal theory. So legal theory that would really compare what types of interpretations, argumentations there are in Europe. If you take the decision-making practice of the Court of Justice of the European Union, you will find out that the judges are using inconsistent terminology and inconsistent approaches. So, for example, in Germany you have the distinction between interpretation and development of law. That means Auslegung and Rechtsfortbildung. But in France, you only have the interpretation, a broad notion. And in France, you only have the logical and grammatical interpretation. They do not discern other types. Of course they do, but they hide it under the notion of logical and grammatical interpretation. In Germany, we have these famous four types of interpretation by Savigny, again, replaced by teleological, etc. So this approach of comparing the methods, the legal methodology in various countries, which is basically the same, but the comparison of these material contents of legal theory is something that can bring us closer to establishing some common methodology or theory of European Union law, which can then again influence somehow also the national legal systems and national theories and national methodologies. at least with respect to the contents of the national legal theory, because you have to cope with the existence of European Union law, you have to cope with the existence of directives, regulations, and the relationship to the national legal system, so you should include that into the contents of the national legal theory. So there is certainly a convergence going on. There already is a convergence with regard to methods, almost the same problems everywhere, methodological problems, but we are also witnessing this material, substantive convergence, both with respect to the European Union law as well as its application in the national legal systems. And that's it, and I really am looking forward to the discussions and to the comments and your experiences, the experiences of our colleagues from other countries, so that we can that's also comparative undertaking. Thank you very much.
Thank you, Tomas Gabrish. It was very valuable. And I think particularly how you describe the development of transformation via education, because that's obviously perhaps one of the best ways how to see the change and how to document also the change in this transformation. I have one quick question. Legal methodology as a concept arose indeed, as you described, via German legal theory only in the early 90s, and I do not think that I haven't frankly been researching the Soviet legal theory, although when I was studying, that was typically I was documenting, methodology itself was not part of the basis of the Soviet legal theory. So that's basically a novelty, also I assume in Europe.
Yes, in Germany, the legal methodology was basically established by Savigny. He was one of the first who basically wrote about the legal methodology. And it was basically a methodology of application of law, adjudication in private law disciplines.
Yeah.
The Russians, before the Bolshevik Revolution, they were studying in Germany quite often.
And the Savigny was also one of the sort of sources.
Yes, they did that. Even they introduced the idea that legal norm has a hypothesis, a disposition, and sanction.
Still alive.
Yeah, that's still alive, and that was introduced by the Korkunov, who was the legal theoretician who studied in Germany, and he, in Russia, he introduced this, and it was then taken over by Strogovich, and Strogovich, in his textbook on legal theory, has then further developed this in our territories, so that's something that we are still working with. But in the textbooks of the socialist era, there was always the first chapter, the first 60, 70 pages were devoted to the methodology of law and the methodology of legal scholarship, but in a very, let's call it, primitive way, saying that we are using dialectics. That means whenever the law is not fitting the needs of the working classes, you don't obey the law, but you obey the needs of the working classes. That was basically the main principle, the main method that was mentioned there.
This could actually be developed into a separate branch for the discussion, because the rather formalistic or positivistic approach to Soviet law would absolutely be in contrast with what you said. But let's spare it for some other more audiences that would be narrower. If there are no other questions, we could move on to Professor Gabriel Kalitz from Tartu University. And,
Yeah, okay, good. So thank you very much for this opportunity to be here and to continue with this very broad subject, especially trying to answer the question how national is the theory of law in the common European legal space. We have heard already many different approaches on that point. And it seems to be that there are a lot of questions, but no clear answers on that point. I would like to present some statements, maybe they are provocative, but anyway, to keep in mind whether there is still a place for the national legal theory, or is this legal theory influenced by some characteristics or some tendencies. There was a question basically saying in our first presentation, who is responsible for the legal theory? Are they judges or academics? That's a good question. But what we have to take into account is still the fact that we are surrounded by the different international organizations. So, which means that meanwhile, we have established already a quite huge number of the different norms and also the theories what are behind of these norms by the international organizations. Well, let's take the example. There is a nice organization which is called International Labour Organizations in 1944. They established the principle which is that the labor is not a commodity, which means it's not possible to conclude the sales contract with the employee, but it should be something different. Since then, there is a huge number of the books and the theory which tries to explain what is the labor, why it is not a commodity, and how we should deal with it. Before that, there was no discussion on that point, and of course, through this legal theory, we have the new understanding of the labor, which means that now it's dignity at work. What does it mean? What is the dignity wage? And what is the dignity at the workplace, and so on and so forth. So it means that international organization as such can still influence the legal theory behind of some subject. The second point, what is also important, when we talk about the national theory, the national legal theory, then this national legal theory is also influenced very heavily by the other countries, by the neighbor countries. And sometimes the countries, they will take over the norms, the legal acts, but not only the legal acts, but also something that is behind of those legal acts. So, which means not only the black letters law is important, but also the theory behind those black letters understanding. So let's take an example, the private law, which was not touched upon. But this private law, especially in the case of Estonia, is a very good example. Because at the beginning of the 90s last century, there was a very clear political statement: we will base our private law system on the German law. But it is not just a law, but it's also behind it. There's a legal theory, how to understand, especially what is the contract, what do the private parties do in the private law relationship, and how to deal with that. But of course, we have also very general theory, which is applicable everywhere, which means, especially in Europe, that is a freedom of contract, that's recognized in every country. And we have also the rule which says pacta sunt servanda. So these are very clear understandings, and we have to deal with them. But coming back to this German understanding and also the German influence of the legal theory is in that sense important, because even our Supreme Court, the case law, has stated unless we do not have any Estonian comments or Estonian legal theory, then there is nothing to do. We can also apply the German theory and also the German case law. So that's why, as you can see, there is a very heavy tendency to be influenced by the German theory, although the Supreme Court can also build. Now it's a question what we talk about, is this interpretation, or as the German said, is a Weiterentwicklung, depends on what we're doing. But basically say it's again, when we talk about this kind of national theory, law, we have to really be careful what we are talking about, because is there really something national in the legal theory is already a big question, because it is really influenced from the different sides. But if you continue with this private law issue, then the situation is a little complicated in other fields of private law, like family law and inheritance law. By the way, also the first speech was very good one. There was also explanation what is the family, oh sorry, who is the family, how does it look like, and if you still remember, it's like late noon, there was a long sentence explaining, right, what is the family. Family is the social, family is the legal, family is a very important unit. But it makes no troubles, because there is a theory which was elaborated somewhere in the 19th century, talking about the family, which usually was, a couple who was married and there were 2 children. Nowadays it's not so easy, because as we already have seen, here we say, keep in mind, a family is not just 2 people, but it's a legal formation, social formation, and something more, which we do not know. Of course, from the legal theory, it's very interesting to see how the family has developed, because it was also said already that the law deals, and especially the theoretical law deals with the situation that has happened already, and now we try to explain what is this. And the same has happened also in the family law, because there are a huge shift in understanding what's a family, and now the legal theory tries to catch up and explain why these changes are taking place, and how legally to establish what's a family. But this is the one aspect of the family in the private law. But when we look at other branches, the social law, and we talk about family benefits, then we have really troubles, because this concept of the family, which is elaborated in the private law, and also which is founded by the private law, is not applicable for the social law. Because the social is a very practical field of law. Because the politicians also ask, we need to know how much we will pay benefits and to whom. And it is not just to say, that's a social or legal entity, but the Social Security Administration would like to know to whom I will transfer the money. So that's very practical. And so that's why if you look at national theory law, and taking into account the family law and social law, then that can be really the understanding that this is really a poor national issue. We have to establish very clearly who is the family, from the legal point of view and from the theoretical point of view, because the same concept of the family does not fit to other countries, not at all, and they would have also the other understanding how big or how many members the family has. So in that sense, and also important is, as I will come back to my beginning, when I stated that there are still international organizations, and those international organizations have the influence also with the legal theory, then in the fields where we do not have a lot of international rules, which tries to explain something to us, then it might be that there are much more space for the national legal theory. But coming back now to the last presentation last night, that was a very interesting sentence. European Union is the melting pot of the national legal theory. So that's true, which means we can elaborate whatever we want, but everything will stop by the European Court of Justice, saying now we will decide what is wrong and what's right, and now we have to establish our own theory, our own legal theory, how to deal with it. But if there are some fields of law which is not touched upon by the international organization, still the national legal theory could have the importance. The next aspect, what I would like to refer is the social law. As I said already, the social law is a very political law because it needs a lot of money. But anyway, it's also based on the legal theory. Because the same principles what we can observe, the human dignity, and when we create norms, it means that the norms should be clear enough, and also that people should understand what they have a right to claim on the state, still has its limits. Because every country can establish its social protection mechanism on their own, and also the legal theory behind that can be different. Of course, there are choices around the world, and now the question is what kind of choice the country will take, but still behind that is still the theory, even the legal theory. But again, sometimes this legal theory that we try to develop is still stopped by the international organizations. One example, occupational disease. The idea is, when there is occupational disease, who is responsible for the damages? And now the international theory says employer. And even if the national legal theory tries to convince someone that this is not a task of the employer, but also the employee has to take care about the safe working conditions, it's zero. Because the international level has said, the European level including, no, nothing to do, because we have this legal theory which says that the employee must be the weaker party in the employment relationship, and therefore the employer has to take care about him. And this theory has never broken. it's useless. You can do everything you want, it doesn't work. Why? I really don't know, but it goes back to the history again. Because yes, well, when it started, that was the end of the 19th century, then indeed the employee was a weaker party. Now when we have already approached the new century, 2024, I have already doubts at that point, but as I said, the legal theory still keeps it very tightly, saying if you start to think about it, something to do in the social relations, like social law, employment law, keep in mind, employee is all the time the weaker party, whenever it costs and whenever it will last. And in order to conclude my observations, to come back again, this protection of the weaker party. That's, from my point of view, it's a very good example how the legal theory started to influence sort of developments, and how, for example, the national legal theory will be not the national but even the European one or international. Again, as I said already, the concept of the employee and the employee protection is one of them, because everything started basically again from Germany. So at the beginning of the 20th century, the German scientists started to discuss the theory about the employee and the employment contract at the beginning. That's a huge discussion. And then, what is also important, this theory was taken over and recognized by the European countries. And since then, as I said already, it has developed, and until now, the European Court of Justice has also stated many times employee is a weaker party, and there is no possibility to change the theory, or although we would like to do that. The second point, what is also interesting, is that when we talk about the other point, the private law, the collective agreement, also a nice historical development of the legal history, because, you know, when we talk about the collective agreements, then the collective agreements somewhere at the beginning of the 20th century were forbidden, really, because that was really the penal punishment to the fact that you should try to conclude the collective agreement, because that was something, you know, mysterious. And as the collective agreement was also surrounded by the strikes, and the strikes at that time was basically saying the criminal offense. There's no possibility. But then again, at the beginning of the 20th century, there was a German scientist, Hugo Sinsheimer, started to develop the legal theory about the collective agreement. And he really established, I don't know where and why, established that the collective agreement is something unique. No, it's not an agreement between the private parties, but it's the legal source of the employment law. And that was, let's say, I can't say that was a scandal, but still something new. And since then, every country again looked at this theory. You can also follow the book, because they are very famous one. And then they started thinking, yes, maybe it is also interesting, this kind of approach. And what's important, the Dutch civil code took this theory and put it into the law, and said collective agreement is a legal source. And since then, no one has doubts on that point. And if you try, for example, now on the national level to say something vice versa, making some legal theory that the collective agreement is not what we really want, then it is also quite complicated to say that this theory is not valid. So again, what is also important again, what I wanted also to say, the national legal theory will start from one country, but it can go to another country. Well, like this example, the theory of the collective agreement was really a theory, just a piece of paper. I even don't know whether the Hugo Sinsheimer has imagined that he would be very famous at that point. But still, what is important, this legal theory, what we have, should also be recognized. Because if you have a theory which is not recognized, then this will be only the theory and no one knows how does this theory develop. But if it's recognized also by the other countries, by the other scientists, then it will develop. And then it will really start to develop on the national level, and whether it will be accepted on the European level, the European Court of Justice is another story, but still, even if it will not be accepted by the case law, but if it's accepted by the other academics in other countries, then we can see that we have succeeded, which means our national theory is now really the European one. So that's all from us. Thank you very much.
Thank you, Gabriel Davids. This is really a remarkable exploration on how, on this clearly an example that touches upon all of us sitting here, either as employees or as employers, has developed, and how you demonstrate also the fluidity of the concept of theory or application of rules of theory of other legal systems. As I see no one wanting to engage into discussion at this point, we could probably move on to the next speaker, who is Thomas Bergmanis, Professor of Social Law at the University of Pitavas. Thomas, please, the stick is yours.
Thank you. I wanted to be sorry in advance that I will not use slides. I haven't brought slides, but I brought to you the whole legal theory of Lithuania in 3 books.
That's precise. Thank you.
My presentation would be actually, how to say, more focused on the current state of legal theory in Lithuania. Because, first of all, I wanted actually to say thank you to Yanis Kleps for inviting me to this wonderful event. I really envy you that you have such event in Latvia, such community building event, really something to behold. So Yanis asked me to say something about legal theory in Lithuania, what is more maybe status quo, the situation. So I prepared to reflect on that, so I brought the books, and I will try to present you what we are doing, how we are teaching it, and so on, because to make this more historical approach or angle would be, I think, could be object of different, of other presentation, for example, to linger on interwar period, on Soviet period, it would be rather complicated. Anyway, for me to cover even this period of after restoration of independence, it's rather complicated, so sorry for being maybe a bit fragmented in my presentation, but I will try to do my best. But I will start maybe a little bit from a side. I'm not a professor of social... How you mean it?
Social law.
Social sciences. Actually, I myself, my PhD is in philosophy. So I'm more philosopher, consider being myself a philosopher, although life happened that I have to dive into legal sphere. I also have degree in law, but my PhD is in philosophy, so my angle may be more philosophical one, I don't know. But let's now still speak a little bit how we teach legal theory. So when I have started to teach legal theory in my faculty, I immediately have done it differently than in other schools of law in Lithuania, and that was because our dean was American then, and he considered it more as a matter of jurisprudence, legal philosophy, and I still think that he was more or less right. What concerns connection between legal theory and legal philosophy. Also, he even questioned whether the subject legal philosophy, jurisprudence, and legal theory was needed at all in legal education, because in the United States they do not have such subjects. Anyway, after some short experimentation, I have settled on Lloyd's Introduction to Jurisprudence for the subject as the main manual. However, eventually it appeared to be also rather complicated to regular students of law. So to jump ahead a bit, because I lecture this subject already for more than 20 years. For now, I base my lectures on this book, Lloyd's Introduction to Jurisprudence, and also a book by Raymond Bax, Understanding Jurisprudence, Introduction to Legal Theory, for doctoral students. and the subject is called Problematics of Legal Philosophy. And for regular law students, we now base our legal theory course on certain books in Lithuanian by Lithuanian authors. So there are essentially 3 main books. What we lecture here, I consider exactly more, I don't know, encyclopedia of law or introduction to main legal concepts, but not legal theory or legal theories or legal philosophies. Although it's in certain respect it contains a certain general approach inside this presentation of main legal concepts, I would say it's just positivistic logocentrism at its core, or as a matter of its fundamental framework, and actually indirectly broadcast to students this positivistic mentality, so to say. However, in our regular integrated law program, we also have separate intensive course on legal philosophy called the Legal Philosophy, Justice, Society, Economic, which is lectured for the last year or 5th year students and is based on Michael Sandel's book Justice and this corresponding course in Harvard. Although we adapt it to Lithuanian reality, so we take more Lithuanian examples and then analyze utilitarianism, Kant, Rawls, Aristotle, and so on. But now let's come to this more traditional legal theory course that now is lectured for first-year students and is based on certain Lithuanian books. So for a long time, this book by Alfonsas Vaišvila was the main authority in the field of legal theory, and his book was reissued a few times, and they were the main manuals of this subject for law students. This book is the first source on which it is based, as Vaišvila notes, is the Lifshitz book in Russian. And his approach to this subject is based on a few fundamental and I think debatable assumptions. First of all, it is fundamentally logocentric and very much based on corresponding positivistic paradigm. So it presupposes certain diachronic, abstract diachronic sequence, circle, where law starts to exist in so-called legal consciousness. And this domain of legal consciousness is articulated rather vaguely. So it's like the core is certain circles. So and there are, how to say, those levels of existence of law, which are presented as certain doctrine, and the first level or first stage of the existence of law is legal consciousness. Then there is certain intermediary level from legal consciousness to legal norms. Then the second level of the existence of law is legal norm. Then intermediary level is from legal norms to legal relationships, and the third level is legal relationships. And then there is like certain also connecting path from legal relationships to, once again, legal consciousness, and sometimes it's formulated like as an attempt of social interest to become general interest, I don't know. But anyway, there are certain, how to say, I think very unclear places in all that, especially how exactly legal consciousness is articulated and how exactly law starts to exist in legal consciousness. It's a problem. And of course, why it is debatable and problematical, so my approach is because of all the problems related to logocentrism. And the most important author, of course, in this context, I think, is Hans Kelsen. But I think, in some sense, Hans Kelsen himself rather well understood the complexities of this logocentric approach. For example, that it is really a complicated task to articulate the so-called world of logos, reason, or thought, that for that we need special language, conceptology, that we may need metaphors or even poetic forms. For example, Kelsen himself writes the word higher nor in quotation marks, and this way showing that he understands that he speaks in metaphors. But Vaishvila, he is not, how to say, exposing this understanding. So anyway, so students are somehow aware, and still sometimes they are presented with this this approach as some kind of doctrinal background, and I think it's still, in some sense, irreflective of all what happened in general philosophy in 20th century, especially what is related to so-called linguistic term in philosophy that presupposes certain critique of this approach. So this holistic understanding of law in the framework of abstract, diachronic and logocentric circle, from legal consciousness to legal relationship and back, still pervades how legal theory is structured as a subject. And in other manuals, we could also find, despite certain elaborations and inclusions in relation to, of course, presentation of schools of legal philosophy, we still find the same abstract diachronic circle. For example, in another book which was published later by the collective of authors, we find that they eventually, after presenting schools of legal philosophy, they still then jump to the same abstract diachronic circle. They start from norms. Of course, they somehow miss legal consciousness, but the norms, legislation, realization of law, interpretation of law, and legal relationships and legal responsibility. So the same abstract diachronic circle is there. And also in the newest book by Vilnius University, we also find, despite certain elaborations, the same structure here repeated. Another fundamental assumption on which Vaishvila's book, which was and still is one of the most influential in Lithuania, I think, is based, is that legal theory is possible a certain kind of legal doctrine as strict science, and this they also means that we should be able to separate it from legal philosophy. So these are like separate subjects. But if you look closer to how Vaishvila tries to argument this idea, it immediately appears to be rather controversial. So, for example, in this book, he writes that the difference of legal theory from classical legal philosophy as general argumentation about law is that legal theory investigates what the law is, and legal philosophy analyzes how the law should be. So, and that's the basis for the conclusion that legal theory and legal philosophy should be different disciplines. But it's how then later or in other places he writes, and what he writes is very controversial. For example, in other places he writes that there is no universal legal theory, that there are many answers on what the law is, and that legal theory even should seek to analyze how the law should be developed. Legal theory, not legal philosophy. So how this question is different from the question what the law should be, and so on and so on. So he tries to differentiate between legal philosophy and legal theory, and this is in the manual, which we should say to our students, but then in other places he says what is essentially contradicts to this approach. Also, he says that this legal theory as a matter of science of law, as discipline of law, was formed in the 19th century. So it presupposes that the question what the law is, like it was not raised before that. But of course it's not true. And generally I think that the question what is first of all, philosophical question. Philosophy, in many its branches, raises the question, what is what? What is being is the question of ontology, what is good or bad of ethics, what is politics or political philosophy, so what is law is the question, I think, central question of legal philosophy. So now, but he says that's a question of legal theory. And the question of legal philosophy should be what the law should be, not what it is. So I think it's still some, how to say, complicacy of this approach. And other books, shortly, so for a long time this book was the one book that we could rely on lecturing this subject from this more doctrinal angle. Then other books started to appear, so this book was the second one. And this is a typical book prepared by a number of authors. The consequence of this is that they lack certain coherency, uniformity, as the book by one author, by Vaishnav, which is more coherent book, I think. And in this book there are some repetitions, some parts are considerably larger than others, some are written in rather different style and approach. And yeah, there are some very really debatable parts in presentation of schools of legal philosophy, for example, legal realism. But anyway, it's still, I think, already better, and for example, I myself use this book more in my lecturing of this introductory course. I think they really very well articulated the concept of collision of norms, and they separated between collision and competition of norms, that they could be two separate concepts. For example, if we have this collision of, let's call it contradiction in norms. So if the cause of this contradiction of norms is deliberate regulation by legislator, it's deliberately left, then we have exactly competition of norms, yes, and which is solved by giving the priority to special law, not the general law. But if we could somehow prove that the contradiction is the consequence of legislative mistake of law, then that priority should be given to more general law. So they propose this approach to how to solve this problem. Also, I think they better articulate legal interpretation. Although they, for example, when enumerating methods of legal interpretation, they also mention so-called logical method of legal interpretation. For me, it's a little bit controversial to mention it as one of the fundamental methods of legal interpretation. And finally, the newest book is Vilnius University book. So Vilnius University just recently published their legal theory, so to say. And it was the first book that tried to articulate the concept phenomenon of the gap of law. What is the gap of law? Lacuna, yes. Although not very clearly, so, but at least they attempted to do this. If you would be interested, I could comment more on this. But to spare time, so finally my remark would be, I think that one of the problems in relation to understanding the legal theory and articulating it adequately is also that people who work in the field of legal philosophy and theory usually still they lack the competence in general philosophy. For example, in order to more or less adequately understand theism, you have to know Immanuel Kant and German idealism rather well. In order to understand actually Hart or Scandinavian realism, you have to know analytical philosophy of language, Wittgenstein also rather well. Otherwise, the consequence is rather shallow presentation of the subject or even certain oddities. And to finalize with the example, there is one there are two philosophers who have exactly the same name and surname. One philosophy is philosophy of law, another is philosophy of language. So do you know who I am speaking about? They have the same name and surname.
Austin?
Yes. John L. Austin. I think Vaishvila actually he misunderstood. He said this John L. Austin, about which H.L.A. Hart speaks in his introduction, is that Austin of 19th century, which is a legal philosopher, but he speaks there about this philosopher of language. So yeah, you have to know this philosophical context. So thank you.
Thank you, Thomas. This has really been quite amazing to hear that some theoretical considerations have been built on a simple human error. But these things happen, you know. My quick comments on the gap of law concept. I think that this is one of the remarkable cases where Latvian courts have been extensively using doctrine of law. And we've evidenced that courts sometimes have to run, if I may say so, ahead of a legislator to deal with apparent and obvious gaps of law that the legislator has not managed to properly take care of. And this has been one of the examples where really the doctrine comes into assistance.
Yeah, but how exactly to understand this concept of gap of law, so that the definition is how you define exactly gap of law, how you understand it. It's a problem because, you know, how to say, when we have the case must have this legal ground. It has to be based on law if you make a claim. So if you have no this basis, essentially you cannot make a claim. But then we have this concept of the gap of law. Then in certain situations, still the court has to adjudicate despite that there's no legal ground. And then they try to theoretically articulate, they use other vague concept that there are certain relationships which should be regulated, which is a rhetorical statement, what it means. Certain relationships should be regulated. Of course, there are certain articulations in theoretical field that there are certain fields of social relationships which should be regulated as, for example, those property relations. If we could categorize certain relationship as property relationship, then it should be regulated. If it is not regulated, then it is the gap of law. But still, these are rather big generalizations. So anyway, and for me, it's in itself interesting phenomenon, this lacuna gap of law. How theoreticians try to of course, in practical field, we know it and we sample can. We have analogy of law, certain solutions, how to solve it, but otherwise, how to articulate it logically, adequately, theoretically, it's complicated.
Well, thank you. I guess this is another topic that we could certainly develop on further, but again, being in the time pressure, I have to say thank you, and let's move on to Jānis Kleps as a conclusive speaker on this panel, and I'm looking at jūlijs, who will obviously be an observer, a non-legal observer.
Illegal, you want to do.
I will listen to your summary, and then I will make my conclusions. But before jūlijs, I guess since we have an audience of really patient listeners, so far we obviously may have questions for all of the other participants or remarks. So after Jānis, the floor is yours for questions and remarks. And I know that one of the listeners, Kaulis, I guess you have a question reserved for the panel. So the panelists remain alert.
Yes, thanks, Lauris. And indeed, Arvids put me also in the list for some comments, and it's a bit hard to speak as a last one, because I think everyone expects some conclusions and right answers. And maybe one of the reasons is because I'm sitting on two chairs, not only academical now, but also in judiciary. And so court always speaks as the last one. And I think we start discuss this point about 2 chairs in the morning session, how to be legal theorist and judge in one capacity. And I would like to say it was tricky for me. We had a lot of discussions with Zdenek previous years on this matter, and I even bought one book in Amazon, Richard Posner, How Judges Think.
Yes.
And I found there a very excellent answer, because when we are doing science, we are somehow, society expects that we are doing it somehow with passion, even obsession, to find new categories, to prove our theories, to push forward our concepts. And when you are a judge, and I think Zdenek reflects this point in the morning session, when you are a judge, you should limit yourself. It's not your duty to push forward your concepts. And it was a point which was stipulated by Posner. And he wrote a lot, indeed. And Judge Posner said that, I would like to say that society have no rights to the, I don't know, over-competent judge. So society has a right to the average judge. It means that if you are dealing in the field of law as a judge where you have passion, you somehow are socially dangerous. And it's a point which you should reflect. And it's the reason why I sometimes limit myself. And moving forward, I will give some key points concerning Latvian legal theory, current actual topics, and some actual figures here. And how you think, can lawyers become pop stars? Can lawyers become a figure of popular culture? Sometimes yes. We all know very well RBG, Ruth Bader Ginsburg. You can buy t-shirts, you can buy coffee mugs. There is also movies, and sometimes it's feelings that it happens only in the States. Here it's in Europe, it's not possible. We are too boring, we are too official, we are too speaking about different things, it's not actual society. But if you are dealing legal theory in Latvia, in broader sense, you can become something like figure in popular culture. For example, my colleague in the Supreme Court, Sani Kosipov. We have graffiti, we have slogans, and we have, I think, a whole movement concerning her attitude to the human rights and application of the Constitution. And so I think that a lot of people citating her, giving quotations to her, maybe even without deeper understanding of this complicated and quite boring legal theory. And I think this picture gives opportunity to understand that dealing legal theory is the right thing to do in Latvia. Because we have here also my dear colleague Lauris, Agris, Salvedis are somewhere the leading figures of industry, managing advocates. And you are spending Friday with us discussing legal theory. That means that it's not boring, it's practically useful, and industry understands necessity for legal theory. And as an academic, I feel that industry understands necessity of legal theory, legal philosophy, and all these sub-disciplines. But what is very, again, crucial, of course, that we develop legal theory in dialogue between academia and legal practice. And so I would like now stress 3 short points, which is actual right now in Latvian legal theory. And I think it will be the same somewhere else, also in our region. First point, good legislation. How to prepare better laws. And it's, I think, looked against jurisprudence, and we had long discussions and very sparkling constitutional court judgment a few years ago, after which here we had discussion in Rapnieki. The parliament was shocked how anymore we could adopt laws. And that they said that politics is end because lawyers push their hands on the preparation of new laws. But indeed, there is still these discussions, and when you Google, for example, these words in Latvian laba likumdošana, good legislation, you will find a lot of judgments. It's something like new mantra. To have a properly adopted law, if this law should be adopted according to the principle of legislation. Second point and second big discussion, and here I think we have key figures, at least President Levits, my colleague Lauris, Ineta Ziemele was here, and concept of constitutional identity. The core of constitution, fundamental values, which are unamendable, and you cannot touch them even in, for example, referendum. And now again, it's a lot of discussions, a lot of publication concerning these issues. And it's coming together at a very topical area. I would like to say these two things also. President Levits mentioned in the morning this development of European Union. Are we going for federal Europe or staying for nation states Europe? It's crucial debate in everywhere almost. But in context of Baltic states, I would like to say there is also one other moment. We should understand that there is only two options: to Europe or back. And legal theory and legal development of Latvian legal system after restoration of independence was mostly based on escape from Russia as far as is possible. And when you are reading text concerning European Union law, you will find in Latvian a big Euro optimism. We don't have a big number of skeptics. But why? Again, it is sociological approach. Those who are Euroscepticals should present some alternatives. And in our geopolitical reality, it's very hard to say these it's very hard name by name this alternative, like quoting Harry Potter. Yes, and of course, again, next also point concerning self-defending democracy. Yesterday's judgment, Ždanoka versus Latvia. And I think we are developing very, very well this concept how to protect, how to defend democracy in these points. So, and third one is dealing with the past. Still dealing with the past. And its application of principle of state continuity, that we are the same state which was proclaimed in 1918, and you cannot, maybe it would sound surprisingly, but we still have cases in the courts concerning the restoration of independence. For example, last month we deal with the issue of so-called propiska, declaration of your place of living in Soviet occupational times, because propiska creates opportunity to become to get a Latvian passport. And it was issued. Do you have VL1 propiska, or this propiska was declaratory? And for example, Court of Appeals had a court session in the field studies. There was witness who walks around the street and tries to remember where exactly was this building, where he met the applicant in 1991 January. And such case is coming. And next, a very important point, and here we are something like similar with West Germany. We are starting to ask what you did in occupation times. Like in West Germany, in 40s, 50s, early 50s, you didn't ask what you did in Nazi Germany. or your parents did. But in 70s it was popular question. And my dear colleague Lauris, I think, pushed forward this debate with very outstanding comment on recent judgment concerning Latvian colleagues will know Kolovaram case. And Lauris, I think, pushed few questions for future discussion on this. How we have to evaluate legacy of key figures, but not only lawyers, also politicians, also poets, also actors from Soviet occupational past. And it's I would like to say it will be very hot topics in next few years, I think. And yesterday we opened one book in English, and I would like to present also one of the leading figures of Latvian legal theory of current days, Professor Daiga. She published her concept of law, I would like to say. A big book in English called General Principles of Law. And in this book, Daiga reflects Latvian legal system, a system based on the doctrine of natural law. She reflects all legal methods as principles, and she is stating that these unwritten general principles of law is real norms binding even for the legislator. And so judge should not only apply written laws, but judge should also overview or scrutiny, does these written rules is compatible with general principles of law. So we discussed yesterday also that the books are very expensive. So my dear friends, it's time to collect money for buying this book indeed. and yes, sometimes yes, it's not so easy to get proper text here. And just concluding points concerning the potential perspectives. I would like to be very optimistic. One, we have new generation of researchers. Elena recently mentioned various parts of the bachelor thesis concerning this legal formalism. We had in our department various parts of master thesis concerning this practitioner concordance. It was great research, offering new attitude to balancing values and balancing principles. And so I think legal theory is thing which can be done with passion, and there is a lot of room also for young colleagues to move in. And also next point, and this is the book of Daiga, we are ready also to contribute to regional, international dialogue, because indeed there is no, I think, such thing that, I don't know, national legal theory without any connections with bigger picture. And the result would be to have or get, but it's dangerous again, legal philosophers in the legal practice, because when we have these artificial intelligence systems which change everything, also routine of judge or advocate, for example, you can just ask, give me summary of jurisprudence of the court. Previously you spent months maybe searching for real precedent. Remember this lovely movie about Devil's Advocate? When this young advocate asks, give me laws concerning this issue, and then is bringing big books and a few wagonnets of books, and here we have this, and now machines can run everything. But the main issue is how to find right, just answer, and then we will need, I think, legal philosophers, because concerning this complexity of life, we should reflect these issues, and so it's I think it wouldn't be boring. Thanks a lot.
Thank you for these really optimistic, conclusive remarks.
In Friday.
It's Friday afternoon, indeed. And I see that we are really coming close to the conclusive remarks, but before that, I see that my dear friend Agris has already crystallized his question, and so will the others. So I will please, Agris,
okay, Jan is a little bit provoked me, and so since you mentioned my name, I have two observations. First, yes, we discussed, or you discussed about possibilities. Is it good or bad to sitting in two chairs, terrorists and judges? But how about attorneys and theorists? The same. Is it issue or not? However, there is an idea because advocates may be very interesting to change something or to use something new. Maybe that's better. However, if you're comparing with the United States, as you know, the judges were the most person who introduced new concepts. For instance, this race segregation, etc., that had been initially started by judges, yes, and that was a very strong movement. But returning back to this industry necessity, of course, we need to know the theory, because advocates looking for something new tendencies, because they can use as at least some kind of argumentation in our position if we would like to introduce something new or defend the new movement, the progressive movement, at least we believe so. But we should practically should open, or I would like to say to destroy the limits what we are having during practical application of the law, because we made it apply written law, formal law, and sometimes we need to have a much wider view on some issues, because that allows us to be not very technical machine who just execute existing law, and we haven't saw and possibilities to think about something high and interesting. And the third issue, of course, my personal problem on citation, because day by day I feel that I need to finish my doctorate thesis, because I see the drive of Constitutional Court and also Administrative Court, especially I saw this last judgment where you was in panel, it is still lacking a theory about personal rights. You're trying to solve issues by old concepts. And it looks very clumsy, but because you see, yes, it's something unjustly, but you have a clear legal theory behind them. For instance, this decision of Constitutional Court regarding inheritance of claiming rights on deceased person on medical negligence. And we have separate views also on this position. I have a little bit, the outcome was good, but I have another theoretical base. And second decision, which I felt, yes, that I judge the panel need my theoretical knowledge, how to justify why another person not lose right on citizenship even in a case of adoption. Because we feel there is some kind of rights which exist even if something happened and formally it could be interpreted, because there is inevitable disposal rights. And this called personal rights. And sometimes person even could forget about them, and minors and disabled persons are especially they could not actually practically defend themselves. Therefore, we as a state and court, we should defend them either they forget or accept violence against them. That is very important. So that's I still keep on this hope, but I believe very soon I finish and probably you will have additional source to refer to.
Excellent. I think, Lager, this was really a great remark, and also promise. We'll keep you to your promise. And
Are you also going to give some promises concerning thesis?
I will be a bit more moderate. I know that I will keep on criticizing court judgments. That's for sure. If I may now ask Calvis for your question, because that was really a summary one, which I think everyone in the panel should reflect on.
So thanks everyone for the presentations. My question was about the common topical issue, and it's about who decides and based upon what how national is the theory of law.
Thank you. So, whether God can create a stone that it cannot carry, who decides? So, let me give a question to each of you who spoke today, a brief response to Carlos's question. Who determines, who decides this question of how national is the theory? And you can elaborate, but not with more than a couple of sentences. And Ellie, how do you comment? Please.
Who decides? I would say, first of all, both judges, academia, and international organizations, and legislator. But I want to stick to a statement by Mr. Levitz a few days earlier. No one has a final answer. So each of these actors, a judge, a professor, a policeman, can propose an answer or give it in a particular case, but there still is opportunity for the next one to amend it, to change it, and so it is a developing process. And I don't know if there are possible final answers. So it's dynamic of thoughts.
Thank you.
There are no final answers. This is really an ongoing process. It's circulation of ideas. The Supreme Court, Council Court cannot prohibit it. Perhaps there could be attempts by the constitutional lawmaker to, I don't know, to prohibit citations. They tried that in Hungary, they prohibited citations from the past. But it's an ongoing process, and it's also, I agree with everything you said, all those groups matter. That's also what the public expects, what the audience, like law students, are willing to listen to. It's also competition of faculties, which faculty will be able to present more persuasive conception of the law. So at the end of the day, no one decides, and everyone.
No, not everyone. Thank you. This is really philosophical. Anything else? Is it okay?
Yes, I agree with Elena that all the groups which she presented participating in the definition of the answer. So, and it's an ongoing process, as Elena said, yeah.
Thank you.
No, I would take the Pierre Bourdieu's theory, which says that it's basically the lawyers who decide what the law is, the legal profession. So it's you.
Thank you. That's encouraging. Gabriel?
Well, it's a very good question, but there are two options. Very short. First of all, when we talk about the judges, they have to deal with the real case. They need to find a solution, because the judge cannot say, I don't know. So in that sense, he or she has to create the theory. There's no other option. And the second one is academics. Academics, they would like to be very popular. And they have to also create something new. And then we'll publish the paper. This paper will be read by the scientists and also by the students. We can force students to read it. And then afterwards we'll see whether it's the theory or not. So in that sense, that both are responsible for developing the theory. And as I was mentioned, very good, by the way, the lawyers will develop the theory. But if we really have to now compare judges or academics, then they both take responsibility. Now the question is whether they accept, their theories elaborated from the judges or from the academics. Well, it depends, but usually we do accept.
Thank you. Thomas?
Oh, okay, so I will make impressionistic answer to your question. Just what reminded me of question, because when we raise the question who decides and when we do not know how to answer this question, so for me it reminded Carl Schmitt, the rival of Hans Kelsen. And What exactly reminded me, in one conference, I remember we spoken with my colleague about Carl Schmitt, and he told the following sentence, that we can hate Carl Schmitt, we can dislike him, but it's rather complicated to negate his approach. So this rivalry between Kelsen and Schmitt, I think, lingers here aside in that situation.
Thank you, Thomas. And Jānis?
Yes, I think I also have some feelings that I need to refer to Carl Schmitt, because his question concerning who is sovereign, and as Thomas answered, we the lawyers are. But here is one complexity I would like to say, that the most important thing is social trust in institutions and in judiciary. Because what we are making in judicial proceedings is something like a big religious things. Something like, we believe that in the Sunday someone changed bread in flesh and wine in blood. And we respect it because we believe in it. We have social trust in this institution. And the same should be concerning rule of law. Society should believe in these proceedings, that we can find just answers. And if we have this social trust, we can move forward. If we don't have, it's a big problem for society. And it's one point concerning, for example, the United States. You can overrule any precedent. Indeed. You can make Nixon right, and you can overrule precedents who are binding for 50, 100 years. But you are losing social trust, and you are showing that you are acting not with this magician of legal skills, but you are just political actors. And it's giving the ideas that, for example, from where comes this idea of court packing? Changing judges, you can change right answers. And it's not so in that way. So I think social trust, and very important figure is those persons who came for the final answers, who start their way to the institutions, maybe first instance, court of appeal, court of cassation, constitutional court, and at the end of the day, not Senate in St. Petersburg, but Luxembourg court or Strasbourg court. So long way for defending of rights. And I fully agree with Alex in this point.
Thank you, Jāni. And with this we have come to the summary, summa summarum summary. Ivars, please.
Yes, thank you, Lauris. First, I just wanted to ask how much time do I have? Because, well, I really admire this level of intellectual sophistication. I had the opportunity to participate in this morning, and I could react to many things, but I had to be rather short, I suppose.
Well, I see.
Yeah, just like you, I guess.
I can tell you, Ineta had actually asked for you to summarize on behalf of both of you. And since you were given time from 1:45, and I'm sorry for this delay, until 14:14, whichever day means, with a glass of champagne, and I know that Arvids will be insistent that we come sharply to listen to Professor Jarolaid's toast at 14:14, so you have time not more than until 14:14.
Good, thank you very much. And this was really a very thought-provoking and very in-depth intellectual discussion which touched upon many subjects. I have to say that, of course, I have limited competence to explore or to comment on all of them. Just for those of you who don't know me, I'm just a really, like Lauris just said, I'm a non-lawyer. I'm actually a professor of political science at the University of Latvia, and my field is political theory and history of political ideas, but I have also some practical experience as a legislator because I am being recently re-elected as a member of the European Parliament. But nevertheless, and that's why, just like our colleague Bergmanas told, my response will also be rather impressionistic. I will respond to topics that are, to my mind, very, very interesting and very thought-provoking for all of us. Let's let's start with the first paper, which to my mind, touched upon the issue which is at the basis of any legal theory as such, and this is the issue mentioned by Elina Grigoreva on the relation between factual and normative, which is really, I think, at the very basis of any legal philosophy. How do we come from what is to what ought to be? What is the process? And of course, what we are dealing with is in jurisprudence is, of course, this normative type of science. And in that sense, of course, this is not the only normative science. There are some other normative sciences as well, like, for example, linguistics is to some extent normative. Logics is normative. But, well, that is a very precise field of the legal science. How, as far as I understand this, and some of you have mentioned, and I think Ms. Grigoreva mentioned from Savigny about this coming of where do those legal norms come from. They come from, let's say, everyday social practices and norms we observe, and some of them, probably the highest level, got codified in laws, got codified in jurisdiction, and how we, this is how we come to the very subject of the legal science. At the same time, I'm a liberal, also in my political party, in my political affiliation. Some might ask, what are the norms existing in the societies that should be left out of the legal regulation? I mean, this is what where the, let's say, European approach to morality and ethics is, that not all morality should be legally regulated. This is about the very limit of legal science. The very, and this, to my mind, is a very crucial issue. Also, most of you mentioned this relation between legal science and political power. How do we see the very role of legal norms in a society? Probably I have to say that, although this is really, I think in my mind, a sad fact, probably the best known legal scholar of Latvian descent is Petr Stučka, the main, defender of the Soviet legal theory, which said that basically law is an instrument of the class struggle. And this is what was promoted up until the very end of the Soviet Union. Well, of course, we do not see law today as something like that. But then, again, what is our precise conception of law and why it is needed? And, well, at the same time, I think that also being a non-lawyer, I have to say that, well, of course, we see something like a closure of this legal mind, and this is where of legal scholars, I want to mention one of the big intellectual authorities of mine and influences. This is a German sociologist, but also a legal scholar, Niklas Luhmann, who spoke about those operative closures of social systems in modern society. And of course, he was talking very much about the law as being something like that, basically, which means that judgments refer to judgments. Where do new judgments come? They come from earlier judgments. Where do new legal facts come? They come from earlier legal facts, which means that this system becomes, it gets closed. And this is where Luhmann talks about this, well, the operative openings, how do political process of legislation influence this proceeding of the legal process. So I have my own reservations about the concept of Volksgeist or nation spirit on constitutional identity, but nevertheless, I don't think that this is, of course, a very separate concept we could discuss elsewhere. Now coming to the, to my mind, very informative paper of Professor Zdeněk Kuhn about this historical approach, and this is what was really a revelation for me. Yes, well, on the one hand, it is the law in Europe is national, mostly, and also, let's say, our education is basically based on our national legal system. At the same time, there is always this dimension of comparison. How do we compare them? And when we start comparing them, then we come to some general principles and how they are being implemented and understood in this or that country. Then, what was a surprise for me listening to your debate was the dominance of German culture, German legal culture, to German legal system, to German court system. This is, I'm coming from social sciences myself, and that's why we social scientists, we usually refer to Americans and to the British. Well, we don't talk much about Germany, and because, and well, what we see here is that in this, I mean, we're talking about Slovakia, we're talking about the Baltic states, we are talking about Czech Republic. We see that the Germans still is very present in those debates, especially because our legal tradition comes from the German sphere. On the other hand, of course, this is probably also a response to your question, Professor Kuhn, about, well, why are we looking at Bundesverfassungsgericht, the main authority? I mean, because this is, and I don't think this is a big problem. The problem is that this is largely an asymmetrical relation. We are looking at them, they are not very much interested in us, I have to say. And yeah, this is, for example, some of you might know that the last Institute of Baltic Forschung was closed down a few years ago in Germany. They are not very much, well, interested in intellectually exploring what's happening here. But nevertheless, we are looking at them. I think that this relation should be made much more symmetrical one in the future, and this is at the same time we shouldn't be also denying this German influence in our region. And proceeding, I think that we already discussed in the previous session the issue which was treated mainly by President Levitz about this constitutional democratic state as being at the basis of the EU and of the EU treaties. To my mind, this is a really topical debate, but we shouldn't be opening it today because it's very lengthy and there's many different aspects. But I just wanted to refer to another dimension of discussion which was also covered by Engels in his earlier work. This is this issue of militant democracy, self-defending democracy, Wehrhafte Demokratie. And the question is whether we see the EU functioning, the EU as an international organization of a very special kind, but nevertheless, the EU functioning as an instrument for preserving democracy, as an instrument of militant democracy. There are, well, ways how the EU tries to keep all those 27 member states on more or less democratic, rule of law-based track. And well, in that sense, I think this is where, well, really the EU law and national democratic systems come into play together. Well, I wanted to say about what was said by Professor Gabish and Professor Beckmanas on the developments of recent developments during those 30 years after the fall of the communism, how was the legal theory developed in our countries. I'm not very much informed about details of that process, but nevertheless I think that this is at least also in some other, both in humanities and social sciences, we see that there is a certain theoretical attitude that, well, the last big theory which really tried to cover all the possible aspects of social relations in our region, of course, was the Marxism-Leninism, which was imposed by Stalin as an extremely dogmatic and extremely rigid and extremely closed system without much of room of discussion. Well, in the late 1980s, we officially got rid of that, and the question is what comes to that place? Probably nothing. There are no big theories like that ones. This means that, as far as I understand, legal theory gets very much compartmentalized in a sense that there are certain theories for administrative law, certain theories for criminal law. There are no such, well, if you want, general theories. I might be wrong because I don't know the details of this particular field, but nevertheless, at least coming from the political theory, I have to say that this is at least not my impression in my field, that people do not much like theory. I think they are very much applied, very much instrumental in what they are dealing with. So what I wanted to comment on some other questions, I think that most of what I wanted to say was already covered. Let me finish with the question of judges versus legal scholars. This is also what was mentioned by Yanis at the end of his presentation, and this is what I really like. He quoted an author saying that yes, a citizen in a democratic country has a right to an average Jew and not an overcompetent one. This seems to be there seems to be a point. We basically, when we go to a court, we really want a judge which is, well, doing his best in his realm of professional activity, or not getting into some kind of creative, anti-orthodox approach to how this particular law is being interpreted. And this is where I see still some kind of a division or still some kind of a conflict between these two identities, being a legal scholar and being a scientist, basically. Being a legal scholar and being a judge. Because these are, to my mind, two separate identities of how I understand science. In science, all the questions are open to debate. This is where all answers are preliminary answers, where each and every judgment could be overturned by the next argument, by the next facts coming in, and by the next development. When we go to a court, we basically really want, this is where the buck stops. This is where the decision is being taken. Well, and we do not treat all the court's decisions as open ones. And this is where I say still that there is, probably this is just like Yanis mentioned, that this is really an issue of self-control. If you are really a legal scholar being a judge, and this is what in many European countries is the case, where judges are at the same time professors of legal science, they really they have to separate those identities, at the same time, of course, being informed about the recent developments in legal theory also in other parts of the world and other countries in Europe. And one of the factors which I wanted to finish my closing remarks with is, of course, this issue which wasn't mentioned of Europeanization. This is, to my mind, also the issue of legal education. How international is our legal education in our universities? We have seen in Latvia those departments have been opening up gradually, and this is also how influences are coming in. This is how people start talking, thinking about their particular fields in legal science in all possible realms of jurisprudence. And this is, I think, also a way, and this is why I think one of the very few problems which is not broadly contested in the European Union and in the European Parliament is, of course, the existence of Erasmus Plus programs, because this is really an achievement in a sense that we can provide our youngest generation of students, in this case of law students, with European experience, and hopefully it will stay like this. So thank you very much.
Thank you, Ivars, for this excellent summary, and also with some of the points that certainly could be brought into an endless discussion, which I hope we will at least pursue for some of the following minutes. Now we can move all in an organized fashion outside to listen a toast of Professor Javle. But also, as you see, there's a very important part of the program which is actually concentrating on those of us who have been largely silent over those few days. So these are our next generation lawyers, the bright stars, many of whom are invited here because of their achievements. We know we have the program of apprentices, if I may say so, for those who are best in moot court sessions or otherwise excel themselves in the academic world, are invited to join our sessions here. And not only from the University of Latvia and the Graduate School of Law, but we also have one Latvian origin student of the University College London. And Gustavs, we're very happy that you are not concentrating on your studies in the UK, Brexitish UK, but also in Germany, as I know, but you're also coming to Latvia. So I think this is one of these bright items I'm very happy to bring with me, as I have emphasized, Latvia is not only losing grain, but gaining grain in a sense. What I wanted to say about this, there are a number of people whom the concentration of whom is extraordinary, and I would ask you, please, our dear foreign guests, spend 5 to 7 minutes for each of those students who will be happy to have a quick discussion with you about, in principle, 3 or even more questions, but one is, what shall I do as a young lawyer, or as a young potential scholar, as a young practitioner? What would you suggest me? Number 2, where do you see the lawyer's world is going? Am I in the right position? And number 3, maybe very practical ideas that you could share. And of course, the basis of this discussion with you, dear friends and guests, is what should you do to receive the achievements that you have received? And yes, I'd say certainly
some short comment after you.
I'm sorry?
I would like to have some short comment.
Oh, sure. I thought that you could add, but so don't be surprised if these young lawyers will want to talk to you, and please be proactive. So you may start a conversation yourself as well. And we can do it either here, sitting in the hall, but I would think most of us would prefer to go outside and to have this, as it's called, speed dating session. I hate the term, especially given the current circumstance, but these speed discussions or speed debates with our young generation lawyers outside with a glass of juice, water, or some may have even champagne.
Yes, but still I have 2 minutes and it's time to say big thanks to our foreign guests today session. And indeed, Ivasia mentioned exactly that one of the points is internationalization of your legal education, more openness for sharing experiences, broadening our knowledges. And it's the reason why, on behalf of Arvids Draunieks, I would like to say big thanks to our friends who came yesterday and today. And Tomasz, thanks a lot.
Thank you.
I hope that your invitations can still...
And our Lithuanian friend, you have different books, this time in Latvian. But I could shortly explain why. We had in 1920 elections in Constitutional Assembly in Latvia and in Lithuania. But paradox is that Latvian Constitutional Assembly was partly elected in Lithuanian territory. And Lithuanian Constitutional Assembly was partly elected in Latvian territory. So here it's possible to study new research of our historians. And just more closing points, but I mixed. I think I will switch to Latvian. Grāmata ir pieejama, tā kā ja kāds vēl nav ticis klāt, tad es nemāku teikt, jo man liekas, visi latvieši, kas ir runājuši, jau vakar tikuši klāt no tā laikuma šeit. Vai? Biogrāfija. Jā, deputāti.
Ja kas to grāmatu paņemt priekšstāvā?
Un tagad es gribētu pateikt arī pašam Jānim lielu paldies par ļoti aktīvu dalību. Tā skaitā arī pasākumu organizēšanā un viesu uzaicināšanā. For being this engine of thinking on the regional collaboration with academicians and also practitioners from Central and Eastern Europe. So keep on. Thank you. Further on, I would like to thank Ivar Sijaks. To make this valuable, non-lawyers view on legal issues. Then, Gabriel, thank you very much also for and Zdenek, thank you very much. This is one of the most interesting parts of today's debate about sharing two chairs, sitting simultaneously on two chairs, academia and also judiciary. And which actually was also basically brought up by Elina. And of course, I'd like to thank also Egil for as always thinking at least 3 steps ahead. And remember the topic Egil's brought up, we will see that in motion in the future. And I would like also to thank Anders Miltan for being and as a step forward, as a transitory moment to go to our toast, which will be most important. So the other line, I'd like Professor Janlaid has been a regular guest and he knows this place very well. I'm sure he doesn't even use Waze to drive here. That's it, Janne. I guess we've yeah, time to go out. And thank you very much and see you next year. Thank you. Yeah.